tomorrow, my lords.
Specific performance of contract, they are moving for execution. Not CPC. Specific performance. They have passed an impugned order against us, my lords. 2024, fresh matter.
There is an expert eviction order.
My lord, MFA matter, my lord. This case was dismissed, filing a memo for posting. This was dismissed due to not payment of court fee. My lord, this will be done immediately, my lord. Recalling application has been filed. 5/9/2024. That's okay.
Which madam?
There is an urgency. Expert order has been granted. Miscellaneous has been rejected, so that's why.
My lords, in list number 3, this one, memo for withdrawal. 11, list number 3. Macho.
My lord, MFA 4847/2022 disposed around 14th/8, my lord. Actually, matter 13th July, it posted to 19th/8 only. I am for R12. Without intimation, it pre-posted on 14th/8. And appellant counsel obtained order, disposal order, alleging fraud against my client, actually with misleading facts, actually. It is not first time, my lord. On 14th, I humbly request to, hence, I am calling for recalling, seeking for recalling, my lord, seeking for a hearing, my lord, for me. Because I am not present, I did not get any intimation, my lord. 14th/8, not get any memo, etc. Yes, madam, it is in the process only. Madam, my lord, it is posted to 19th/8, my lord, actually, but without any intimation, it is listed on my 14th. It is my fault, my lord.
Lordship, serial number 7, you finally have it next week. You no interim. No.
Serial number 17, my lordship. 17. I appear for respondent, my lordship. Arguing counsel is not well. I pray for 1 week's time in this matter, my lordship. Please, I have informed, my lordship. Status quo order is there. Grateful. Status quo order is there, no? That may be continued. Grateful, my lordship.
Serial number 2023, your lordship. Appear for petitioner in this matter. We have to file few documents. I have secured it. A week's time may be granted, your lordship. We'll file it. Yes, your lordship. Interim order is there in the first matter, your lordship. Next week, your lordship. Great. Interim order.
Serial number 25, my lordship. I may be permitted to serve the copy to the other counsel, sir. Other side defendant, I want to serve the copy. I may be requested for 1 week time, sir. Delays there, 5 days. No order, sir.
I appear for petitioners, serial number 43, my lords. Pray for 1 week time. I am a proxy counsel.
46, my lord, I appear for respondent. 6, my lord, I appear for respondent. 46, 46. Pray for a week's time. They only served copies here as of yesterday. I will inform. Please. I tried reaching them, my lord. Please.
The petitioner.
Here for the respondent.
Respondent is.
We have moved for the being spoken to, my lord. In the final order, this typographical error, my lord. In the last operative portion of the order, 0.9, my lord, the visitation rights it was given to the father was on third Saturday and Sunday, fourth Monday. 9,
11.
11, my lord. 11. After the third Saturday and Sunday, the fourth Monday of the month, the father can exercise visitation rights between 10 AM to 4 PM. The order was actually, unpronounced was 4 PM to 6 PM. Because your lordship may kindly say that's a working day and the order on 26/3.
No, it's true that it was 4 to 6.
School.
It is true. May I only make one request, my lord, if it appeals to your lordship. I come all the way from Hyderabad, 1,500 kilometers to see my son for 2 hours. It could be extended by a few more hours. That's all I'm requesting. 1,500 kilometers, my lord. He drives 2 ways. 3 weekends.
3 weekends he has.
3 weekends.
Both the alternates.
Correct. Ma'am, only it's a request.
My lord, on 6th point, my lord. 6th, my lord. On the, my lord, on every month, there is a weekend, he has weekend visitations on 1, 2, and 3, and the 4th is with the mother, my lord. 3 times in a month. 5th weekend, there's a Saturday and Sunday. He takes 1 day and the second day with the mother. The word mother is missing there, my lord. Instead, it says 10 AM to 6 PM. And Sunday it is with the mother. That it should have come in that payment.
No, may I make one? Lord, there is some confusion that's between the parties now because sometimes, like the last weekend, 31st was the last Sunday of the month. Fifth Saturday, sorry. Sunday was the first Sunday of the month. Lord, may I request your lordship, my lord, to word it this way, my lord. The Sunday following first Saturday, Sunday following second Saturday, and Sunday following third Saturday, father will have visitation. Fourth Saturday, Sunday, mother anyway has with her. If there is a fifth Saturday, father will have, and Sunday following fifth Saturday, mother will have. That because otherwise, this weekend is making up. No, the Sunday following the first Saturday of the month, father has. Sundays following first, second, third Saturdays of the month, father had visitation. Sunday following Saturday. Saturday and Sunday, first, second, third, Saturday and Sunday, father has. Not the Sunday following the first Saturday of the month.
My lord, what he is trying to say is first, second, third, fourth are clear. The 5th Saturday and Sunday with the father for 3 days. And fourth Saturday and Sunday is for the mother. That is not a problem, my lord. The 5th weekend, 1 day for the mother, 1 day for the father. That is 3 times in a year or 3 or 4 times in a year, it comes like that, my lord. In last year, this last weekend, it was 31st was a Saturday and 1st was a Sunday. The 5th week did not have a Sunday. So that's why they're trying to, there was a confusion on that. So on that day, mother will not get visitation rights. So that may be.
Mother has custody. That may not be
that
correct.
5th weekend will not. If it is Saturday, you will have that. On Sunday, if it is not there, it is not there. That's
If
all.
I may clarify, sometimes what happens is the last day of the month will be on a Saturday and the first day of the month will be on a Sunday, like the last weekend. Confusion arose because my client has correct.
Other month.
Therefore, it would be easier Sunday following first Saturday. Yes. Saturday I have. Correct.
It will be his.
And Sunday also I should have because your lordship have said first Saturday and Sunday of the month. The first weekend I will have. The mother said no because it's fifth Saturday and the Sunday following. Therefore, she did not give me visitation on Sunday. That's what happened. That's the confusion that happened, my lord.
He went.
She did not allow me.
Huh? It's sad.
She said, no, I will not allow you visitation on Sunday. If that is the understanding, my lord, I have no difficulty. She did not allow me. She did not allow the visitation on Monday, on Sunday.
This month again, there's no first.
That can be clarified, madam. It should not be a problem. There was an understanding, and the only thing that said this should not be insisted on every week is what was mentioned. So that can be clarified. Not a problem.
No, I'm sorry. I think the order is also missing only one aspect. Video calls on Tuesdays and Thursdays, your lordships are permitted by interim order that was continuing throughout. It is not, does not find a mention in the main order.
We are following it.
We are following it.
Tuesday and Thursday, I'm not for about half an hour video calls.
Video calls.
15 minutes.
15 minutes.
Tuesdays and Thursdays, no, 15
Tuesday
minutes was
and
what was
Thursday.
given earlier, that was 1 year ago. I'm requesting only 30 minutes for Tuesday and Thursday.
The child will not even sit for that long.
If
we
we, up to 30 minutes,
if we can hold the child, what would happen? They'll play the video and start, they'll keep the video on, but don't really interact with the child. They sit and watch. What
I
do
don't
they
know
say?
why this, not up to 30 minutes. If the child is not being interested, we'll cut the call. I don't know what my
They
clients
will
and
be
client would lose.
abusing the child. He will be
Abusing.
shouting at the petitioner. There will be a verbal duet.
This
Let
is-
there be 15
this
minutes,
is-
my lord.
This is
Understanding, my lord.
a new allegation that's come up for the first time before your lordships. All this while, everything was fine. 15 minutes more, I asked for some allegations.
But if the child does not sit, then the mother abuse will
Up,
come at the
your
mother.
lordship is up to 30 minutes. But I'm not saying it has to be. Absolutely, absolutely. I've never forced.
Are you going to say?
Absolutely, but he's a small boy. Attention,
Take on.
correct. And attention span also may not be much. All I'm saying is up to 30 minutes. Even if it's 5 minutes, but if it stops, it's fine. Up to 30 minutes is what I'm requesting. Absolutely.
Subject to child's cooperation, my lord. That clarification would resolve all problems.
Saturday.
It's been. 7:30 PM for 15 minutes.
Obliged. Yesterday.
Hearing for the petitioner in the above case, my lord. My lord, I'm filing before the court payments, my lord. That it was sought for clarification on payments that the respondent was receiving from the father. And I am filing it before this honorable court, my lord. My lord, it is marked in orange for the kind of perusal of this honorable court. Page 1 to 4. Page 1 to 14 is the bank account of the petitioner, my lord. Page 15 to 30. It is marked, my lord. My lord, on 11/8/2000 says it is gone to Shilpa Shri. 60,000. 60,005. Yes, my lord. And similarly, it was even paid on 11/10. No, my lord. On most of the months I am paying, and then I have paid school college fees of my son, 2,50,000. It is on 21/12/2000. No, it is on need basis, my lord. It is on need basis. There were sometimes frequently. Then she started receiving from my share of the family property from the father. That is in if you on 8/3/2022. Page number 15, my lord. From Mahesh and Ars to Shilpa Shri, 63,000 discount. It is marked, my lord. And similarly, on 10/7/2000. Six 2023, my lord. Page 15. Yes, my lord. So, my lord, can you please tell the date, my lord? I request. 8/3/2022. Yes, my lord. Correct. Yes, my lord. 60,000, my lord. 60. Yes, my lord. Yes, my lord. Correct, my lord. Approximately it is going because on 5/4/2022 it's gone, ma'am. 2022. 63,000, my lord. Next page. 63,000. On 6/5/22 and 6/6/22, 40,000 each have gone, my lord. On 6/5 and 6/6, my lord. Yes, my lord. On 27/22, 60,000. On 27/2022, 60,000.
Now, where do you find her name here at page number 23? That it is transferred to her?
1 minute. My lord, it is her account only, my lord.
Okay. You filed this in the registry?
Yes, my lord, will file.
Yes. Which is the date of petition? You have not filed the petition,
I have filed the petition.
and then you will have the date on that.
I only have the date of passing of the order, my lord. I am just.
It's
looking.
there on 10/8/2021. Why are you not finding it at page 39?
Right, yes. I apologize. Yes, ma'am.
You will take this date when you have filed the objections because
Yes, my lord.
that's not
21/1,
visible.
2023 is when IA under section 2024 was filed.
2021,
21/1, 2023, my lord.
it's 22. Right. Agreed with the order passed with the trial court, passed with the family court, where maintenance of an amount of rupees 40,000 is granted to the wife. The husband is before this court. Learned counsel submits that every month an amount of rupees 60,000 is being transferred by the parents of the
Petition.
petitioner to the wife. It is submitted that in between, he has also been paying the amount, and in fact, he has also taken care of the educational expenses of the boy. He has placed before the court the bank statements to the court, which he should have filed before the registry. The bank statements discloses that there is transfer of amounts from the petitioner's father in favor of the respondent. The said aspect is not mentioned, is not observed by neither pleaded nor observed by is not stated by the wife. Considering all this court deems it appropriate to pass an order. Hence, there shall be stay of all further proceedings pursuant to the order dated so and so. On the condition that the petitioner shall deposit an amount of rupees 10,000 by 5th of every succeeding month, and the arrears set rupees 10,000, he shall deposit 3,60,000 within 8 weeks from the date of receipt of the copy of the order. He shall take notice to the respondent and educate appearing with the respondent, hand summons, and shall file a memo to that effect by 23rd of September. If pose this matter on 14th of October.
Yeah.
Then number
It will
three,
be only 10,000 per month is 1,80,000. 18 months I am due as per the.
3 years.
Okay.
3 years.
Yes, ma'am.
Yes,
then number three, Rachita Rashekar for petitioner, Cyril Prasad Payas.
Appearing for the petitioners, my lord. My lord, you directed us to pay 15,000 as maintenance. Our client is paying, my lord. So matter may be taken up next week.
are they paying?
They are paying. Last month they paid.
And you have also withdrawn
Yeah, they're directly paying my account.
account. The land council for the petitioner submits that as per the orders passed by this court, they're paying the maintenance, and the land council for the respondents also submits that the payment is made by the petitioner at the request of land council for the petitioner. For this matter on 12th of November.
Then number four, Nataraj BS for petitioner, Arun Govindraj.
Yes,
The petition herein has challenged the order passed by the trial court by considering the application filed by the respondent herein, Order 7 Rule 14A, on the ground that there is no pleading at all either in the petition or in the evidence. It is well settled position of law. When there is no absence of the pleading, no documents cannot be considered before the trial.
let's see.
I am filing this authorities also before this lordship by apex court positions.
No, first we'll see the
Yes.
impugned order, then
Yes.
we'll look at the judgment.
My lordship.
Where is which page?
In page number 42, my lordship. Running page.
Who had filed the MC?
MC has filed by the husband, my lordship,
Yes.
under section 12, not 13, my lordship. Setting aside, dissolve the marriage on the ground of medical ground. Annulment.
Yes. What is the stage of the suit?
Further evidence, done for further evidence going on. Further evidence is not closed. I laid evidence. Immediately after leading evidence, I filed an application for production of additional documents under Order 7, Rule 14.
Where is your application?
Application is produced at page number. In page number 29.
For what purpose you want to file this?
Well, messages between the husband and the wife were exchanged while they were living together. But to her state of mind.
Prove what? You must have stated so in the affidavit.
I've said in my petition itself.
Well, let's see.
Kindly see para 4 of the petition on page number.
No, page number 30 is your affidavit.
Yes. Para 2, Lord, I have said, by inadvertence, I have not produced a document mentioned in the accompanying application along with the petition, though they form part of material in support of allegation made in the petition. Not the allegation is there in the petition.
There should have been a specific contention at the, now when you want to file this application
Yes.
at a stage, not along with the main application.
Yes.
You should say that these WhatsApp messages contain or a simple just for proving my case, it is essential.
But I've said that in paragraph number 3.
In support of my
The
evidence.
document is necessary to prove my case and for effectual
No, It's a general statement. No,
What the message
What is there in this? What is your case? What are these documents?
that is there in para number 4 of the petition itself. In the petition, I've said message
Because the application is not allowed, great hardship and injury will be.
it could have been better drafted. I concede, my lord, but kindly see para 4 of the petition. I've made a specific allegation that the messages are exchanged between the husband and the wife, which go to prove that everything is not normal in the relationship or with the
See that?
person.
Let's see.
Para
Where is
4.
it? Page number
12 to 17 in petition.
17.
12 to 17 is the petition. I think it is page 14. I don't have the page number. So page para 4. Not up 1. 8 lines, not from the. Hence, the petitioner and his mother left Tumkur while she stayed with the petitioner's father at Bangalore due to the course. While the petitioner and his mother were traveling to Tumkur, respondent sent him a message containing hateful words against his mother. Petitioner showed the messages to her parents, but they were not willing to help. And instead, her father mentioned that the respondent has thyroid issues and requested the petitioner to get it treated. These are the messages I want to place on record. This fact was not known to the petitioner, clearly shows that the fact of her mental and other health issues had been hidden by her parents. But ultimately, my lord, the petitioner before your lordship will have to show what is the prejudice caused. You know, ultimately, the burden is on me to prove every single document that I rely upon. What is the prejudice that is caused to to the wife, not by me bringing the documents on record?
WhatsApp exchange between the petitioner and respondent.
Yes.
WhatsApp exchange between the petitioner
And respondent
and
sister and brother.
respondent sister. Text messages exchanged between the petitioner and respondent. Screenshot of the message exchange respondent via Instagram. Pen drive containing, yes.
The burden is on me, you know, ultimately to prove the.
Reason is that, my lordship, this documents are to be produced before lordship was. If they had mentioned that pleadings about this document at the petitioner itself, what are the details exchanges or what are the contents, I would have been filed a different statement of objection to those documents by taking instruction from our client. Second thing is that those exchanges are between, if those exchanges are between the husband and wife, I would have been give consent for that. It is exchange between the sister of the wife and brother of the wife. This is totally not relevant to all those
What is the
documents.
sister of the wife, brother of the wife?
The document what they have produced before the documents is that
That's what it is between the petitioner and responding brother,
brother and sister of the
petitioner and respondent sister.
sisters.
Uh,
Those documents are not totally irrelevant to this case. Reason is that, my lordship, they have taken the contention on that ground that the petitioner, they started dissolution of the marriage on the ground of medical, they have suppressed the facts of, she might have some medical issues, all those things.
No, maybe all these WhatsApp conversations contain that.
This is why I'm making
information.
submission before this. All the conversations are prior to the filing of the petition, not subsequent to the filing of the petitions. When this material facts were within the knowledge of the petitioner, this respondent.
No, that is true. It's filed at a later stage. Because it's filed at a later stage, is it a ground for the court to brush it aside is the question.
I am not saying that. That is
No,
a
it is, no, we can understand. Now, the MC is of the year 2022.
Yes, my lordship.
It is not that after a long time it has been done. When is this application filed? On
23rd of
23
January
2024.
2024.
MC is filed when?
But MC is
That's right.
filed not on
Date?
28th of January 2022.
So,
My
no,
evidence,
even it will be easy for you also to demonstrate how, what is the conduct of the petitioner also.
evidence comments
There
on
are admitted documents. The conversation, what is the
My
prejudice? to you?
condition is that, reason is that, my lord,
No, what is the prejudice to you? Tell the court.
prejudice means this, my contention is that the contention taken by the husband before the trial court is that only they have stated the messages, all those things. But they have not stated anything about what are the things happened in between the petitioner and respondent. One thing. Second is these documents are to be produced before the trial court or prior to that,
No, no.
this
see,
one.
you
And
will-
they have not assigned the proper reason.
That is there.
Why they have
Reasons
not
are not
stated
assigned.
anything about
No,
the.
these are all matrimonial matters. The technical aspect of, in other matters, you can't apply to the facts of, in a matrimonial case.
They have not assigned.
No, with all this, no, if you deny that these are not the conversations between you and the husband. And the burden lies on him to prove that there was a
I
conversation.
can understand that what this lordship is saying, can understand. Only thing is that what was prevented for them to state all those facts prior to filing of the petition, because these messages are taken place prior to filing of the petition in the year 2021 itself. When those facts were within the knowledge of those
That's what,
persons.
they're all called the technicalities. We'll not go into it because it's filed at a later stage, we'll impose some costs. Oh, yes,
I
we'll
can
take
place
that
that
judgment.
decisions, ma'am. That should come to that first decision,
Yes.
pair
this-
number 11.
That's what I said, suit property, permanent injunction.
That is not,
It's not arising out of a matrimonial proceedings. What we apply the parameters in a matrimonial in a property dispute are not one and the same.
my contention is that those facts, what they were,
That I understood, that I
that is the
understood.
reason, my lord.
Para number,
11, my lordship.
para number,
11 of the first decisions, my lordship. It will start from sixth line from the bottom, my lordship. To start from AR 1987 SC 1242. It is well settled that in the absence of pleadings, evidence, if any produced by the parties, cannot be considered it is also equally settled that no party should be permitted to travel beyond his pleading, and all the necessary and material facts should be
When
pleaded
when
by
they
the party in
mention
support
about
of
the
the case.
WhatsApp messages between the parties, not necessary that like a suit in respect of property, all those things need to
My
be stated.
submission is that
Only thing is their IA should, their application affidavit should have been more clear when they're filing it at a later stage. That's the only thing the court finds.
I will leave it to Lordship.
Yes.
Reason is that those facts are well within the knowledge of the party before filing
That's
the
what will
petition
impose some
itself.
cost for that. The,
And that all the conditions should be open for me to cross-examine.
it's always open, otherwise why will, it will be an
They
injustice
will
to
take
the
a condition
party.
that since they are failed before the High Court, they cannot raise objection, all those
But
things.
the order
I
says
know that,
respondent
I
has
know that,
opportunity to
because
cross-examine.
I got experience before that trial court.
Say that, we will observe that. Agreed with orders passed in I number 3 in MC number 612 of 2022 dated 28/2020.
8/7.
This is
8/7.
how, this is how we have to look for the, that's all the difficulty with these orders, sir.
8/7.
Just, in the starting, they should have at least mentioned the date,
It's not.
on 8/7/2024. The respondent wife is before this court. The husband had filed MC number 612 of 2022 seeking divorce,
Not annulment,
annulment of marriage. Where is that prayer?
but that page. No, 18,
70 to 21.
page number should be.
Page number
16.
16, my lords.
Grant a judgment and decree declaring that the marriage solemnized between the petitioner and the respondent on 5th of March 2021 at Hiriyu, Chitradurga district is null and void. It is a case of the husband that the wife suffers from an incurable mental condition that is existed even prior to the marriage. The respondent's the wife's family, having concealed her condition in order to obtain his consent for the marriage, have committed fraud. If the petitioner had known about the respondents, about the wife's mental condition, he would not have given his consent to the marriage. At the stage of, what is it, you said?
Further chief of
exam.
PWN.
Evidence.
At the
evidence
stage of the
petition.
evidence, at the stage
Further chief of the petitioners.
Evidence.
stage
petition
of
evidence.
further chief of the husband,
Yes.
he had come up with an application
In page
under order
20.
7 rule 14 to produce the documents. That's a WhatsApp exchange between the husband and wife. The WhatsApp exchange between the husband and the brother-in-law. WhatsApp exchange between the husband and the sister-in-law. Text message exchange between the petitioner, between the wife and husband. Screenshots of the message exchange between the wife and husband via Instagram. It is stated that in support of the said application, it is stated that he has filed the petition under section 12(1)(b) and C of the Hindu Marriage Act for a decree of divorce. The case is posted for the further evidence. By inadvertence, he has not produced a document mentioned in the application along with the petition, though they form part of the material in respect of allegations made in the petition. Hence, they sought permission of the court to produce the documents. If the said documents are not placed on record, it would cause a lot of hardship to the husband. For that, objections are filed by the respondent stating that without any pleading, any amount of evidence cannot be entertained further. When all these documents are in their custody, They shouldn't have filed this. They should have filed this. It's not working. Okay, but the green light is not here. I think it's not working. Ask them that green light is not coming. Now it is there. What did you write? Documents which are in their custody, they should have filed along with the petition. And according to them, there is no pleading. The trial court, the family court had allowed the application. While allowing the application, the court had observed that
Around 6 months.
that the judgment that is relied on by the counsel for the wife, that is in case of, in the judgment of the Honorable Apex Court, in case of Biraji alias Brijraji and another versus Surya Pratap and others, reported in 2020 10 SEC 729. In that, the evidence of the parties is already adduced, and there was also an order of the High Court for expeditious disposal of the main matter. And the application therein was filed at a belated stage, was dismissed for the trial court on that ground. The family court has distinguished the facts of this case and held that in this case, the petitioner the husband had not yet completed his evidence, and the documents not sought to be produced could not be produced along with the petition due to inadvertence. Further, what had transpired between the wife and husband had been pleaded by the husband in detail, and the message which are exchanged need not be pleaded. And on the other hand, the respondent wife will have every opportunity of cross-examining the witness as to make out the genuineness of the documents which are sought to be produced. Hence, the court had involved the said discussion. Court felt that the court had allowed the IA filed by the husband, aggrieved there by the husband is before this court. Land counsel had reiterated the submissions made before the trial court, and yes, relied on the judgment of the Apex Court in case of Bachas Nahar versus Nilima Mandal and another, reported in 2008 17 SCC 91. Relying on this judgment, Land Council submits that such an application could have not been allowed by the trial court. He had also relied on the judgment which was relied on before the trial court, that is in case of Biraji alias Brijraji and another referred to Supra. Land Council submits that the trial court, without considering the judgment of the Apex Court and the contention of the wife, that application cannot be allowed at the stage. And those conversations are nothing to do with the relief, with the case of the plaintiff had allowed the application. Had it been had this evidence, documents have been filed, had the pleadings have been taken at an earlier stage, you would have got an opportunity to file these objections in that regard. Now, if this application at this stage is allowed, it would cause hardship to the plaintiff, hardship to the wife. Next para. Land Council appearing for the respondent husband submits that in his pleadings, he has categorically mentioned about the WhatsApp messages.
No, no, only messages, not messages.
Huh?
Only messages they have stated.
Yes, mentioned about a message
The
between
messages,
the
that's all.
wife and the husband. And when you're seeking annulment of marriage, all the WhatsApp messages are very much relevant to establish his case that the mental condition of that the health condition of the wife is not normal. He submits that though in so many words, they have not stated so in the application. It is very much necessary for adjudicating the dispute between the parties. It is submitted that no prejudice would be caused to the wife. She would get an opportunity to put forth her case and further the burden lies on the husband to prove these documents which is relying on, and they're necessary for the adjudication of the case, and no prejudice would be caused to the wife. The court had rightly considered the application and passed an order, and there are no grounds to interfere with the well-considered order passed by the trial court. Next paragraph. Having heard the counsels on either side, peruse the material on record. The husband has filed a petition seeking annulment of the marriage on the ground that the wife is suffering with some incurable disease. Yet in the petition at paragraph number 4, he has stated about the WhatsApp message between him and the wife. When the case is coming up for the examination of PW1, he has come up with this application to produce this evidence. No doubt such an application is filed. All those WhatsApp messages are very much in the knowledge of the petitioner even prior to filing of the petition. But he has not chosen to place the same before the court at an earliest point of time. In the light of the allegations and the dispute between the parties, the conversation which he is relying upon might be relevant for deciding the dispute between the parties. This court had perused the affidavit that is filed in support of the IA. In that also, very vague averments are made. The petitioner, the husband should have been, while that application should have contained the reasons for not filing and how they are relevant, but no such reasons were given in the said affidavit filed in support of the IA. However, on the ground that the affidavit is not containing all the details, and on the ground that it is filed at a belated stage, this court cannot reject the application filed by the husband in a matrimonial proceedings, and considering the kind of disputes between the parties, those documents appears to be relevant for adjudication of the dispute. But however, considering the delay and not mentioning all the reasons in the said affidavit, this court is inclined to modify the order whereby this court is imposing costs of ₹15,000 to be paid by the husband to the respondent wife. Accordingly, wife further, the wife shall be given an opportunity to put forth her case and raise all the grounds.
And reason is
accordingly
that,
disposed
my lordship,
of.
I have serious objection with the text messages or any WhatsApp message taken between the brother of the.
No, all the
respondent, all
objections
this.
with regard to this application, the petitioner is at liberty to, the wife is at liberty to raise all the objections,
My lordship.
and the court shall consider the same.
Much obliged, my lordship.
Yes.
Serial number 5, Ita Devi MP.
Petitioner mother is before this honorable court, questioning the order of the family court directing the week overnight visitation rights and permitting the child to be taken to Mumbai of a child who is 3 years, 10 months. My lord, the facts of the case is, my lord, that they have been separated from December 2001. And he has never involved in rearing
December?
2001, 21, my lord, 21. And the child was born on 14/9/2020.
49,
2020.
2020.
Lord, they have lived for 1 year together when the minor child, after the minor child was born. During that period, he is never involved with the child. Even when he is at home, he is an actor. He's either he goes for shooting and is not available in Mumbai. Otherwise, he's at home, he is in a different room because he feels the child is disturbing and he did not take part in rearing of the child in the entire period, either physically,
No, they were
morally.
together after the birth of the child, they were for 9 months, till 3 months only.
No, my lord, 2020
Oh,
and December 2021.
13 months.
So after the child delivery happened in Bangalore and after the child was born, the 1 year she's lived there, my lord. After the child was about 5 months, she's gone to Mumbai and they lived together. There were difficulties, there were differences there between, because he never provided for any financial aspect, nothing he provided for. That is a part. The main point, my lord, he never involved in rearing of the child or building bondage with the child. Now, and there were issues where, because he was not supporting and he was very clear in saying he wants a divorce, but he did not want a financial commitment. So there has been demand made for him and it was difficult for her to stay. She was driven out of the home and she's now staying here. Now, my lord, whenever he wants visitation rights, when the case is pending in Bangalore, when he comes to Bangalore, he's accessed the child and he has come here and visited the child and nothing we have not prevented. Now recently he filed an application. That application is filed on 3/8/2024.
When is this MC filed?
MC petition was filed on
22.
7/2/2022. During this interregnum period, whenever he has asked for visitation rights, it has been provided. He has come to Bangalore, he's
Come to the order, let's see, what is
the order, my lord, the order is for Raksha Bandhan is already over. In fact, the time we could not enforce that order or implement that order for the reason because the child had viral infection.
What are all these photographs? Photographs at 131.
That is, she has rashes, my lord, she had chicken pox. We could not take the child or we could not comply with the order for two reasons. One was the child had viral fever. That is the medical record that has been produced, my lord, at 127. And she had chicken pox. And because of chicken pox, once straight away we cannot go to the doctor. We have done a video call and a video recording and shared it to the doctor and doctor has given the opinion there. And then, my lord, we have gone for confirmation what it was and the medical records also has been there where the doctor has said the Manipal hospital in
Come
Bangalore.
to the order.
Order is Annexure A, my lord. Annexure A.
Page 18.
Reasons are at page 20. Lord, the reasons what we have stated has not been considered at all.
Before that, what were the orders of the court?
No orders, ma'am.
Straight away this order.
Straight away this order. There was no visitation rights, nothing. Whenever he wanted, he came. We never obstructed whenever he wanted access to the child. He wanted a video call when she is not working or she's available. Calls and videos were also
When
made.
was the IA filed?
On 3/8/2000, the order itself contains that, my lord, 3/8/2024. 3/8/2024, the IA was filed.
And this is the first order by the court.
First order by the court regarding the visitation rights. Our application for maintenance is pending for 2.5 years. It's going to be 3 years. Till date, no order has been passed. Despite making repeated requests, the court has some difficulty in passing orders, my lord. Most of the cases, orders are not passed by that, but this particular court.
Which is the court?
I'm sorry to say this, but despite I filed a memo 6 months ago where there's a direction of this honorable court, my lord, to dispose of the case within 6 months when the maintenance application has been filed. No order has been passed till today. That is one of the contention I've taken up, my lord. I placed the IAs also in 7/2/2022 when we filed the petition. We have made this request. Till date, no order has been passed.
So once the appearance of the party is there, why can't it be done in a month? Interim
It
application.
ought to
for-
have been done. And we have filed assets and liabilities. There is a lot of concealment on the other side. So we have filed an application for summoning the documents. On the other hand, the court insists, get into the witness box. Are you leading the evidence or not? Even that has been done. But we are insisting, let some order be passed. The child is going to the school. He has a father, he has to have a responsibility to provide a penny for the child. Nothing has been paid till date from the time the child has been born. Some 5,000, 10,000, whenever he feels that he wants to pay, he will pay. And when he comes, he brings some toys or gifts to the child. Apart from that, nothing, no obligation on the child or the responsibility of the father. That is apart, my lord. Now,
Yes.
Please, my lords.
When an application is filed, straight away, what is the custody of the small boy?
My lords, there's been, even my application for visitation rights is pending for close to 2 years.
No, how long it is not the
My lords, the
issue.
reason being, my lords, may I please explain this to you? There is, I'll in fact, I'll probably place the factual matrix or matrix on record for the fact that there's an age gap of 14 years between the parties to the list. He was a celebrity. He was a celebrity. He was no doubt he was known for his roles and everything. He was pretty famous. The moment he hit rock bottom, the lady leaves the house, takes the child, comes to Bangalore. That's what is happening here, my lords, because it's several facts have not been mentioned for your lordships.
No.
Please.
All those
So
facts.
this
are-
order, the reason being.
Please
this order-
understand, all those
Please.
facts are not relevant. What is relevant here is the boy at the age of 13 months, or 12 months, 1 year, the mother left the father.
Please.
Then the father, then the MC is filed by whom?
The MC is filed by the mother. I want to save the marriage. The MC is filed by the mother.
No, MC is filed by the
They
mother.
take a restraining order against me by stating false reasons. I filed my
No,
objection.
we'll appreciate all that. No, as far as the order that is passed by the
Please.
family court is concerned, no, the boy is like from the day he is 1 year old, he is staying away from the father.
Yes,
Now he is 3 years old.
please. It's about.
No, when the first, when this application is filed, first of all, for a couple of days or couple of
hours with him.
there should be a visitation. Then after that, overnight custody.
Please.
But straight away telling
May I
that
please-
take
may
the
I
child
please?
for two
Probably, my lords,
days.
I'll have to probably appraise your lordships about what happened that day in the court. My lords, what happens here is the modus operandi in the present case is that the mother, whenever the father is directed to be present before the court, before the trial court, the mother exactly a day before calls him up and tells him, okay, you can come down, you can meet the child. He meets the child. Now what's happening is his application for visitation is pending. What the submissions that they make before the trial court is that, no, we are allowing the child to meet. Now the court hearing is done. Now again, the next hearing date is after a month or 40 days. No contact whatsoever. She does not even answer the video calls and he's been messaging her.
No,
this has
that
been
orders
the
will pass.
My lord,
Will
my lords,
pass.
please, this has been the modus operandi in this case. Every court cannot be hoodwinked this way by the other side because that's what they've been doing before the trial court as well. Now, this is a man who's coming, he's flown down from Mumbai to Bangalore the moment I told him that this matter is listed. The order was granted only for 2 days. The order clearly says the mother can accompany the child or any chosen representative by the mother. My lords, quite often in all the custody matters, my lords, the mothers fall sick exactly at the time of the visitation. My lords, I'm being very honest.
No.
I'm sorry, my lords, but I'll have to place
Gautam,
this on
let's not go
record.
into all that. Let's not go into all that. No allegations, nothing. What
Please,
is to
please,
be,
my lords.
what is the solution for that? That only we
Please,
will
please.
look
May I
into.
please place this on record, my lords? 2 days. All that I'm saying, I am being made to travel every time from Bombay to Bangalore. I don't mind doing it for the sake of my son. Now, the mother is also directed to be present before the court. She does not come. They inform me after 3 days when the court passes an order that both the parties are supposed to be present because the trial court would want to talk to them. They inform me after 3 days when he's booked
So
his
how it
ticket.
should happen now? How it has to happen now?
My lord,
But the visitation has to go on now, but it has to go on. How it has
it
to
has
go
not
on?
even been granted by the family court. Now all that family court has to consider that application and pass the order regarding the visitation rights.
Then why are you before this court?
Now, my lord, overnight visitation rights cannot be granted at this age is what we are
So
saying.
when the court says overnight visitation cannot happen, then the court has to say otherwise also.
Very well, madam.
Yes.
Very well.
So what is to be done now?
Lord, he has to
Please
have.
get specific. No, we'll clarify that aspect also. Father needs to see the child. The child needs to have the love and affection of the father. And father also has a responsibility towards the child. Both of them have to be balanced. That we will look into
Very
that.
well, my lord.
So please tell the court like how it should be according to your client. Then we'll ask them.
May I ascertain from her, my lord, and then.
Pass
follow.
out.
Serial number 6.
Tell her and Mr. Gautam, tell your
Please.
client also, he has to, whatever, we will pass an order about the visitation and a pattern will fix later, subject to any other application, you can move before the court. And about your client's commitment towards the children,
Absolutely,
child's,
he's been voluntarily making payments, they've suppressed. That's the reason, in fact, I filed my
no,
documents.
no, no,
Please.
voluntary stage of voluntary contributing is over. Now the court will tell you what
Please.
is to be done. So
Certainly.
please get specific instructions on that. We'll have it in the afternoon. Yes, next.
Grateful.
Serial number 6. Nagarajan. For petitioner.
There's a connected matter with one writ petition 23642. It's listed today in serial number 2 of costless 2, my lord. It's a similar matter. The current this petition, it's a connected matter with writ petition 23642, and that petition is listed at serial number 2 of costless
Number
2, my
two.
lord. Serial number 2 of costless 2, my lord.
Cost is.
Costless 2. It's a connected matter, my lord.
It can be taken along with that?
My lord, if that may be taken along with this.
Yes, what is the matter about?
My lord, it is here,
Number
my
two
lord.
is no, office objections not complete. Will
My
not
lord, the
hear-
office objections are complied, my lord, in both the petitions.
No, list number 2, I have 1/24 to dispense the production of original or certified copy. Protection of, oh, that's how it's coming up.
Yes.
Okay, can you take out that? Yes. What
Madam-
is this petition and what is that petition?
My lord, both the petitions are being filed challenging MC petition and a GNWC petition. Wherein, my lord,
So now we
despite
read,
specific.
no, 1 minute. We are in WP number 24475.
Yes, my lord. This is filed challenging an order passed by the trial court in a MC number 1537 of 2018.
One?
1537 of 2018.
1537 of
2018.
2018. What is the order passed in this?
My lord, the order passed may be found at annexure A in page number in page number 15, my lord.
What is the order?
In page number, my lord, here the two applications comes to be filed in IA 19 and 20, wherein the respondent wife, she files an application
IA number
seeking for
18
the,
is for what?
my lord, IA number 19 and 20, my lord.
19 and 20?
Yes, my lord.
So 19 for what?
My lord, that is for the application comes to be filed in order to recall the stage of cross-examination.
Hmm.
My lord, what happens here is
No, 1 minute.
This-
Recall the stage of cross-examination.
kindly
Filed by,
filed by the wife, filed by the respondent
to
wife.
appear for whom?
I am for the
Husband.
husband, my lord. I'm the petitioner in the trial court as well.
IA number 20?
My lord, it is the same application for recalling the stage of cross-examination.
Why 2 applications?
My lord, they filed two applications, and those applications, my lord, may be found in
So again, as those 2 applications, you have filed 2 writ petitions.
no, my lord. This they filed two applications in the GNWC petition and the MC petition.
Against that, you have filed.
Yes, my lord. Against
petitions.
that, I filed two.
Please come to the order.
My lord, the order may be
MC is of 2018.
2018,
Filed by,
filed by the respondent wife.
For respondent in this case,
ready?
MC,
we have to file detailed objections.
What objections? No objections are required. Whatever is there before the trial court that this court will look into.
Normal
Let's
senior,
stop that objection business in this writ petitions.
normal
Unless and
senior
until a
has
new facts
instructed
are
me to,
stated by them.
senior has instructed me to take adjournment minutes. Kindly move.
Let your senior come on Monday, both the matters.
my lord,
Club,
here,
the post WP number 24475.
my lord, if I may
along
make a
with-
submission, my lord.
1 minute, along with the WP 18627. No,
No, my lord, 23642.
no, so and so, along with so and so on Monday.
My lord, one submission that I would like to, my lord, here the issue is, there is already a direction passed by this honorable court wherein it was directed to the trial court that the litigation, that the trial court matters
That's
have to
why
be
Monday,
completed.
on Monday, we will dispose it of. Both the matters, we should give an opportunity to the other side, is it not?
Yes, my lord, but then again, the connected matter that is 23642 was already posted on Saturday. And your lordship had directed the trial court to place a report as to why the trial was not completed within the stipulated time period.
Receive, where is that? Open this report. But then what is that? Oh, in that she kept,
In the case in which a report is placed, my lord, is writ petition 23642, that's the GNWC petition. Issue is, my lord, repeated adjournments are being sought for before the trial court. Despite there being a specific direction of this honorable court in regard to both the trial court petitions, that the trial had to be
when
concluded.
that 1 month period had time granted by this court has elapsed?
My lord, in the GNWC petition, that time elapses 20 days back itself, my lord.
Then the other case?
In the other case, the time elapses today. The 3 months period, in the MC petition, the time elapses as on today. And in the MC
It is
petition,
from the date of receipt of the copy.
receipt of the
That
copy.
also you've calculated?
Yes, yes, yes. From the date of receipt of the copy.
This court had called for the report. Give the docket.
That is for GNWC.
On 31/8/2024. This court had directed the second additional principal judge, Family Court, Bangalore, to place a report before this court. Why the order passed by the coordinate bench of this court is not complied with. Now, a report is placed before the court stating about the various dates. How the matter is adjourned. What are the matters pending before the court? And finally, the learned judge submits that out of the stipulated period of 4 months, as per the request of the party, the matter was referred for mediation center and 1 month time is granted for settlement, if any. Further, another 1 month, there was summer vacation. Moreover, the parties filed one or the other interim applications, and the court has disposed of all the pending IAs. And the court undertakes that it will dispose of both the MC and JNWC as early as possible. When there is an order by the court to dispose of a particular petition in a particular time frame, and for any of the reasons, if the court is not able to dispose of the matter, it is the duty of the learned judge to seek extension of time. But unfortunately, the report that is placed before the court by the learned judge do not even contain whether such a letter is addressed by the court. Well, addressed by her seeking permission or seeking extension of time. If this is a manner in which the matter is the manner the orders are considered by the trial court, there is no sanctity for the orders of this court and to pass any order directing the court to dispose of the matter. The court shall clarify the learned judge, the so-and-so judge, second additional principal judge, Family Court, Bangalore, shall clarify clarify whether she had sought for any extension of time from this court when the time has already elapsed in both the cases. Post this matter on Tuesday. By the time the report shall be placed before the court, post along with so-and-so, so-and-so. No further adjournments will be granted.
My lord,
to
if
the-
these orders be set aside, my lord.
Which order?
The impugned orders in the GNWC and the MC petition wherein their evidence stage has been recalled.
That's, for that we have to hear them.
Please, Manoj.
We have to hear them, just like that, we can't set aside the order just on the ground that the court has directed the matter to be disposed of.
No, my lord, the issue here is that despite the, when if when the trial, when this
So
honorable
for
court
that,
has
they have
made.
to argue why that apart from, no, can the court, whatever application that is filed, when the court feels that that is in the interest of the parties, it can't just like that brush it aside. The court has to seek the permission for extension of time.
Yes, my lord, but.
That the court has not sought, that we will ask the court. And about on the merits of the matter, let them argue on that day. No further adjournments will be granted, we'll decide it.
My lord, because there has also been one development in the trial court. The trial court had asked the respondents to file an advancement application and finish up the cross-examination stage, and all these developments has happened before the trial court as well, my lord. We have not agreed for the advancement of the case and for the
No,
completion.
I'm
of the
not able to
cross-examination.
understand your anxiety. No, you want the court to dispose of the matter. To pass any order, there is a procedure for that. Just like that, because in the coordinate bench has said 4 months, 4 months time has elapsed, let whatever the application that is filed, let the court dismiss it. That can't be. If you are on the right, on the other side, you will understand the. Yes. Post
My lord,
along with that number.
If they would, if they may take an undertaking to file wakalat.
So what is your name?
Yashwant.
Who is filing which is the advocate?
Mallikarjun.
So and so submits that they undertakes to file wakalat on behalf of the respondent in both the matters. Print the name of so and so. Yes.
Cell number 7 adjourned. Cell number 8. Cell number 8.
No
MJ Alva.
representation, pose this matter for dismissal. Where? Yes.
Claimant's appeal against the allowing of the suit under section 34 of the Arbitration Conciliation Act.
Yes.
The arbitrator has passed the award.
Why this matter notice is not, sir, notice is also not ordered from 2020. It has never come up.
But it has not come up. Notice may be ordered and the records may be called for the trial court.
Notice to the respondents and the registry is directed to call for the trial court records. That's how all these matters are listed. They have not seen the light of the day from 2022.
Cell
Yes,
number
next.
Great.
9. Prakash Angadi BV for appellant. Cell number 9.
Same order. Notice to the respondents.
That's
This is
government,
directed to call for the trial.
government to take notice, my lord.
Where is he? So and so is directed to, what is he called? The-
Macho, some.
Right respond.
No, for that notice will go. For which response?
Private, I will issue notice for R1 minutes for deputy commissioner and special. officer.
R2 and R3.
Hmm.
For
R3 is not there, my lord.
R for R2, so and so, what is it called? Special government Peter or?
Please, AG.
AG is directed to take notice.
Please.
Petitioner appellant shall serve copies on the so and so. The registry is directed to issue notice to respondent number 1. Yes.
That stay of 50%, my lords. Because matter is involved 94,000, my lord.
Huh?
In similar matters, disarmal.
What are you doing from 2022? No, all these matters are listed at the instance of the court. We'll
Please, my
see.
lords. We have
Notice,
put my.
we don't know what has happened from 2022 till now. Pose this matter, yes. Issue notice to the respondent after service of notice, list this matter. Yes, next.
Cell number 10. Mohammed Tahir.
Notice. Notice to the respondent, call for the records.
Cell number 11.
Same order. No, it is.
Appear for the
notice.
respondent, my lord. Chetan K.
You appear for the respondent.
Yes,
No
ma'am.
representation for the appellant. Pose this matter for dismissal on 23rd of September. Yes, 12.
12.
Notice to the respondent.
Hearing for the appellant, my lords.
Notice for the notice to the respondent. Call for the records.
Cell number
Yes,
13.
next.
Judge, we have filed a application for the stay on the operation of the arbitral order, my lord. If I may submit a few submissions.
2022 will not be stayed now in 2024 unless a notice is there to the respondent. Yes, 13.
13.
Same order.
Cell number 14.
14 also same.
Cell number 15.
Yes. 15.
Ashok
Tenth
Patil,
matter.
11, in all these matters, all of 2022, notice to the
Notice.
respondents and call for the records.
But it is already, notice has been served, my lord. The admission is there. Requesting.
R2 and R3, non-filing of objections to I number 1 of it. You are ready?
Lord, objections is ready.
Huh?
Objections is ready, my lord. I am permitted to.
Why objections are required in this?
Very well, my lord.
We'll hear the matter, argue.
The senior has to come,
Huh?
they end up in another matter. my lord.
Pass over,
Kindly
let him come. Let him come and argue. Yes.
Lord,
Serial number
Lord, I
15.
have got inconvenience of.
15 pass over.
Son of
16.
Lord, day after tomorrow. Or Monday, my lord.
Pose this matter on Wednesday. How many matters are there on Monday? Tuesday, Wednesday, look at it. Up to 12 is Thursday. Pose this matter on 18th? Yes, 18th.
18.
Yes, next.
18. Serial number 16. Gita Devi.
Impugned order is in Kannada, my lord, your lordship, kindly permit me. Monday I will file
He
the
submitted
translation.
that the impugned order is in Kannada. List this matter on 18th. The council shall file the translated copy of the order. Yes.
Please, madam.
Serial number 17 urgent. Serial number 18.
I represent the
A Madhusudan Rao.
appellant in this case.
Which case?
Serial number 17 minutes.
17 urgent.
It's adjourned in the morning. They said
That
that
the interim has to be extended.
it is extended.
Sir, I felt that it is not extended.
No, it's extended. 17, again verify. 17 whether it's extended or not.
18.
LCR is correspond merit to be disposed of it.
My lord, in serial
The
number.
only thing is difference with regard to the measurement of the property and the schedule. The trial
That
court
we
has
hear, that
granted
we
in
hear
some
when the matter comes up again. No LCR required in this. Yes,
interim order mechanism.
yes. Next, 18.
18. A Madhusudan Rao.
For the respondent, my lord.
Petty.
In this matter, could the records kindly be called for, my lord?
Where is the appellant? No representation for the appellant. Post for dismissal on 19.
Serial number 19.
My lord, I appear for the appellant in this matter.
You appear for the?
Appellant.
Yes.
My lord, the impugned order is the appointment of a court receiver.
Oh.
My lord, suit for partition and separate possession filed by the sisters.
You are the plaintiff.
I'm the defendant number 2, my lord.
Oh.
The sisters have filed the present suit
Oh.
for partition and separate possession.
Yes.
My lord, in that an application came to be filed stating that the defendant number 2 has been taking the proceeds of the land in question. That is the 3 acre 30 guntas of land. My lord, except stating that there was no allegation as to, my lord, the misuse of the land, the not taking
Please
care
come
of
to
the
the order.
property.
Let's straight away go to the order.
Please, page number.
And what is that? Where is that IA filed for appointment of receiver?
My lord, that has not been filed along with the appeal memo, my lord, that I'll place it later, my lord, by. My lord, that has been a record, called out in, my lord, the page number 9, my lord.
Page 22?
Page number 22, my lord, is the finding. My lord, the relevant page is, my lord, 9 may kindly be. It starts from orders on IA number 1.
Is this the affidavit, page number 22, in support of this IA?
No, that is,
Appointment of
my lord,
receiver.
I have filed here, my lord, for staying the operation and execution of the order.
No. Wait, what is page number 22? Please come to that.
My
22
lord.
of the appeal memo.
My lord, the page number 22. My lord, the 12 is the, I'm sorry, my lord, it starts from 8. The order starts from page number 8.
You said that they wanted an advocate commissioner to be appointed.
No, receiver.
a receiver to be appointed.
Yes.
They must have filed an application for that.
Yes, my lord, there is an application.
Where
my
is
lord.
that application?
That along with the appeal memo, my lord, we have not placed it, my lord, I will place it.
It should have been,
No, that usually they will not entertain, only order we has to be. I'll find it separately, my lord, along with the mail.
no, that is material to know why they want.
Yes,
this
yes, I do agree, my lord, I'll place it.
Yes.
My lord, they said only this much, the finding is, my lord, para 10. Only 2-line finding, my lord. Para 10, my lord,
Let's read from the beginning.
please.
Para 2, we'll read from para 2.
Please. The application is accompanied with the affidavit of the plaintiff's applicants, wherein it is stated that they have filed the suit for partition and separate possession of their half share in the suit scheduled properties against defendants who are their sister and brother in joint possession. Third item of the plaint schedule, more fully described in the IA schedule, is in a fertile areca garden with standing crop estimated at not less than 10 quintals of raw areca nuts. The market value of the raw areca nuts per quintal is not less than rupees 7,000. The second defendant has already harvested the first unripe areca nuts hurriedly to deprive and defraud their interest and to appropriate for himself without accounting. They estimate its value of not less than rupees 15,000. Now being aggrieved by their notice of demand for partition dated 19/9/2022 served on him, has been further preparing to harvest the standing crop and to sell it away and to misappropriate it for himself to deny their claim. In fact, the defendants have got alternative vast income to eke out their maintenance. First defendant has been profitably running a business, and second defendant is a money lender, whereas the plaintiffs are to be supported by agriculture income. In case the second opponent is allowed to harvest the crop without being accounted for it and without the direction of the Honorable Court, they suspect that he would misappropriate its income and gives a false account to deprive them. Hence, it is necessary to appoint any one of the parties with the directions to harvest the crop and to deposit the realized income from it. In case their unwillingness, a court receiver may be appointed for the purpose or in the alternate. The defendant number 2 has filed the objection statement, where it is stated that the suit is filed seeking partition and possession. It is submitted that the first defendant is in physical possession and managing the application schedule since the lifetime of his mother, Srimati MP Geeta. The defendant number 2 has invested several lakhs of rupees for improvement of the garden land as per assurances proclaimed by the plaintiff that they will given up their alleged rights over the suit scheduled property. Now, the days itself he is expecting the crop. In fact, nothing in this order or rule shall authorize the court to remove from the possession of the custody of property of any person whom any party to the suit has not a present right so to remove. As such, the plaintiffs have to establish that they are having present right to remove the defendant number 1 from the custody of the suit scheduled property. The plaintiff ought to have established their entitlement for
Who
the
is defendant number 2?
my son, my lord. There are 3 sisters and
So
one
defendant number 1?
is another sister. It is mother's property, my lord. In the year 2001, she filed a suit for
Brother
partition.
is the plaintiff.
No, mother is not a plaintiff. Mother is
No, brother.
No, other 2 sisters are plaintiffs. There are 3 sisters.
Defendants are?
They are also sister and brother. There are 3 sisters and 1 brother.
Defendant number 1 is sister, defendant number 2 is brother.
Brother, yes. He is the younger brother and he was there with the mother, and he was the one followed up the case and other things and spent money and obtained a judgment and decree for partition and separate possession on behalf of the mother. Thereafter, my lord, he has improved this land. All the 3 sisters are married and residing separately. Now, my lord, they have filed a suit. The contention is that on their assurance.
So what is the purpose of appointing a receiver?
Only, my lord, they want to take away
Monitor.
the.
They want to monitor what is the
Monitor.
income
Yes.
you are deriving
Yes,
from the
yes,
sale
madam.
of the property,
Yes.
sale of the proceeds.
Yes, ma'am.
What is wrong in it?
No, my lord, they want to take the possession from the defendant number 2. My lord, in a suit for.
Where do you get it from the order? Please come to the order.
Once a receiver is appointed, my lord, receiver cannot be appointed only to sell the proceeds. That is
But
not.
the problem is court has not mentioned what is the purpose of
Correct.
appointing the
That is, my lord, absolutely there is no finding. Kindly read. My lord, the court has not applied the mind. In fact, they said.
There are two eventualities. One is that for managing the property, and the other is now that their whole case is that you are going to sell that proceeds, whatever
Has-
is the
it
crop
has
that
to be.
is there.
Yes.
No, if the receiver is appointed, he will see what is the amount that is fetching and how much you're deriving. So in case if it is held that it is a joint family property, then that has to be shared by the other co-partners.
My lord, as far as that point is concerned, it is not only for, in a case of appointment of a receiver, 5 important points has to be taken into consideration. One is, my lord, that the prima facie case has to be made out. The second is the party must plead that not only the appointing the receiver to collect the amount, there must be a pleading that the party who is in possession has not been taking care of the property and there is a urgent and requirement to see the maintenance of the property. My lord, with all these 5 points, my lord,
No,
then
what do you say about now you are selling that?
my lord, that
standing
has to be
property?
sold. That has to be sold because
It has to be sold, that's why.
the
No,
only thing
what
is,
what the
yes.
court understands from this order is, court has appointed receiver only for the purpose to monitor what is that you are selling, what is that you are deriving out of it.
My lord, as far as that point is concerned, my lord, we will undertake that, okay, this is the amount what we are getting and we are going to
So
deposit
if
certain
the
amount.
receiver is there, what will happen?
No, receiver, my lord, is a third party. He will interfere with my possession.
Not
And my
possession,
lord-
that should be clarified by the court.
My lord,
What is that the receiver is going
my
to
lord,
do?
yes, my lord. For that is the purpose, my lord. Kindly see their application is to say that whether any of the parties.
I've seen their application, that is at page number 22. It is somewhat appears to be in respect to this only, page 22. They
yes,
only
ma'am.
speak about that you are selling the
Correct.
standing crop.
For that purpose, the court cannot appoint the receiver. My lord, ultimately, there will be in a suit for partition, ultimately there will be an inquiry for the mean profit. My lord, in the mean profit, all these things will be taken care. My lord, that is the purpose. Appointing the receiver is concerned that in a number of cases, the Honorable Supreme Court as well as our own High Court has said that these 5 points, that ingredient should be there, then only the receiver can be appointed. Therefore, my lord, especially in this case, kindly see the paragraph 10. Para 10 of the judge order. There is no finding whatsoever on these points, but court even has come to the
You
conclusion
appear in
that,
this case?
my lord, para 10 may kindly be
1
seen.
minute.
Please.
You file your wakalat or you're going? Huh?
Appellate, ma'am.
You're for appellant or
Appellate.
Huh?
Judgment,
The
madam.
counsel is there, what is that?
No, I have given the judgment.
No, my colleague is there, my lord, to present the judgment. That's all.
Yes,
My lord, para 10 may kindly be looked in. The only finding, my lord, is 2 lines.
that's what, that is not, there is no clarity in the order.
There is no clarity, there is no application of mind. That is also there. Kindly see the court.
Land counsel for the petitioner, land counsel for the appellant submits that the court without application of mind, without giving proper reasons has appointed a commissioner and
Receiver.
and the reasons that are given by the court cannot be the ground for the court to appoint the receiver, not the commissioner receiver. He submits that the defendants are in possession of the property and they've been cultivating the same. And no, a third party receiver cannot be appointed without giving any reasons. Next para, this court has perused the order of the trial court. The order do not contain any of the reasons why the receiver is appointed. In that view of the matter, they shall be stay of all further proceedings pursuant to the order dated so and so till the next date of hearing. The appellant is permitted to take out notice of the counsel appearing for the respondent and shall file a memo to that effect by 30th of September. Pose this matter for hearing by 27th of September. Pose this matter on 14th of October.
Much.
Yes. Next.
20.
Pass it over.
28.
Pass over.
4:30.
Yes,
Still number
next.
21.
Kindly pass over the matter, minutes. Senior counsel
I'm
is-
telling the advocates in a passover matter, again, you ask for an adjournment in the afternoon and
No, no,
you
no,
post
no.
costs on that.
No, no,
That's what is happening every day.
No.
Yes, passover.
please.
Number 22.
Kindly pass over.
having the cross-examination in the trial court. I'm waiting for marking. And moreover, they have not furnished the synopsis, which has been directed by the Honorable Court on the last date. Now, today, they have served the copy.
Matter on any stay is there? Pose this matter on 18th of September, 19th of September. By the time the appellant shall file the synopsis. No further time will be granted. Yes, next.
Interim matter may be extended.
Why should it be extended when you don't file the synopsis?
Synopsis is ready, my lord.
You are ready to argue now?
Need to argue, kindly pass on, my lord.
Now itself, let him argue. My lord, I cross.
Why not now?
Senior is, he's
18th.
ready to address the
18th. Yes.
Pardon?
18th.
18th. Interim
Not
matter,
18th, 19th.
interim matter may be extended.
The model earlier granted is extended.
I am urgency.
12th. 12th is the 12th will. Yes.
12th.
19th, this matter 19th. 19th.
19th.
Yes.
Interim matter may be extended.
Interim order is extended.
Please, sir.
Yes.
23 urgent, cell number 24. Ramesh Kumar.
It has come up on the earlier also.
Yes, my lord, last week. Listed. So the plaintiff's files, IA number 28.
What is this council submission with regard to
But with
any?
regard to my lord, the others are not made as parties, the appeal. My lord, the relief is, the appellant is not claiming any relief against other defendant. It is the application
You should
file.
show them as parties and then you should mention or a memo should be filed. You just straight away cannot delete them from the cause title.
I'll carry out. I'll carry out.
The appellant shall comply with the office objection.
They are
Pose this
placed
matter.
ex parte before the trial.
But you
I'll
have
do
to,
that.
that
I'll
you
do
have
that.
to do. Cause title should contain
I'll carry
everything.
it. My lord,
Then-
date make.
12th?
12th.
12th. Pose this matter on 12th for it.
Much of.
Cell number 25.
Yes. There's a delay of 6 days in filing.
Yes.
Shall order notice?
I'll serve the copy to the defendants.
Notice to the
1 week
respondents,
time.
notice to the respondent same petition is permitted to serve the hand summons on the council. Wherever I say notice, it's hand summons on the council appearing for the respondent. And shall file a memo to that effect. When can you file?
1 week time.
Shall file a memo to that effect by
15.
15th is holiday. Shall file a memo to that effect by
17, 18.
by 19th.
Right.
And if the memo is filed, list this matter on 23rd.
Much obliged.
Cell number 26, T. Sheshtrao.
Yes.
It's an appeal not emanating out of the Protection of Interest of Depositories Act. It's like in all states, even Karnataka has this act to protect the interests of certain depositories, whose deposits are placed in sometimes banks, financial institutions, or
Switch on
cheat-
the mic. Yes.
cheat fund agencies. So, sir,
Yes.
they should be better. Now, my lords, the respondent, no, the current appellant, my lords, was the respondent number 2 before the trial. My lord, she was neither she was neither the promoter, nor an employee, nor a director, not in any form, not she was attached to the financial institution, which was in the name and style of Raghavendra Saharda Cooperative Society. It was a bank, where due to certain due to certain lacuna, the bank was unable to repay its depositors, including all its customers. Therefore, the KPAD Act was invoked. Now, what the special court is doing, is it is trying to attach properties which belong to the bank. It is trying to attach properties which belong to the promoters of the bank. It is trying to attach properties which belongs to the employees, whom the special court.
The order impugned now.
Now, my husband, at some point of time, he was a vice president. He passed away even prior to the proceeding commenced, even prior to the bank getting into insolvency mode. Not now, not my properties which stand in my individual name, not even my husband's properties, not they are sought to be attached. And no reasoning is given. For one moment, not if my lordship.
No, against an order passed by the special court under the Depositors Act, what is the remedy, MF?
This is an appeal, minutes. There's a circular which has been passed by this court also. It is to be treated as a miscellaneous first. RJ 179 of 2022 is that circular number. 16 is the appellate provision, minutes. And this is the circular. Minute, I'll just provide the circular also
Give
for
the
one.
act.
Yes, minutes.
Section 16.
Section 16 of the act, and why the miscellaneous first appeal, minutes. I'm sorry, I don't know, I can pass this or not.
Please pass on.
Please. This is the circular.
Before that, what it used to be?
This is appeal, minutes. It used to be numbered as some appeal minutes, but because the KPID appeal started coming in higher numbers minutes, there was a the circular was issued. Sometimes minutes it used to be numbered as writ, sometimes as revisions. This problem was there, and we never used to invoke the proper appellate provision also sometimes. So that is why minutes a circular was issued that any order assailing the KPID special court's order will be treated as an appeal, interim or
Come
final.
to the order.
Not now the order starts. Not set the running page 16. Not lordships may see the findings would only start it.
You have nothing to do with this first respondent?
No, I have absolutely nothing to do. Not I'll just point out not what is my plea before the lower court. Also, I'm sorry, it's not the special court. I'm so sorry.
We'll just read the order so that
Please,
the court will
the
understand.
analysis starts at 28 minutes.
Now let's see the facts also.
Please. 18 minutes for a moment. Two B minutes there. It is further the case of the petitioner. This is what I explained that the bank went into insolvency, the first paragraph. It is further the case of the petitioner that Shri T.S. Satyanarayana was one of the directors of Respondent Number 1 Cooperative Limited. He has purchased the property in the name of his wife, Srimati T.S. Nirmala, from Srimati B. Shakuntala, so and so, with a sale deed 22/4/2019 for a consideration of rupees 43,45,000. Respondent number 2 is holding the property for and on behalf of her husband, T.S. Satyanarayana, and she has no source of income. Hence, the property is treated as a personal asset of T.S. Satyanarayana. Hence, the petition schedule property is liable for attachment. Accordingly, the petition schedule was attached by the government on as per section 3(2) via notification dated 2012-23. Considering all these facts, in order to protect the interest of depositors, the government has was pleased to provisionally attach the property acquired in the name of respondent number 2 with the funds of respondent number 1 cooperative.
It is of the year 22/4/2019.
3 minutes.
As on the day, your husband is the director of the said company.
He was the director of the
Said bank,
Yes, minutes. Yes.
society. And what is your source of?
I was a teacher. I was a teacher. Minutes.
How much you have purchased the property?
Minutes. This property stands purchased
The
for around 43
consideration of
lakhs.
43 lakhs,
So 43 lakhs.
45,000.
Minutes. My grievance.
Was it reflected in your income tax? Or was it reflected in your?
Yes, minutes.
Where is the discussion come to that?
Minutes. Kindly see, minutes. There is no discussion on this for one moment because the respondent number 1, the authority does not choose to leave evidence at all. Kindly see, minutes. The plea what it has taken before the special court is to this effect. Minutes. Under this act, minutes. Initially, minutes as a preventive measure, minutes. All properties are sought to be attached. Then, minutes. It is left to the special court to minutes confirm the attachment or not. So provisional attachments are made under section 3(2). Then minutes, these are laid out before the special court to verify. Now minutes, kindly see the crux of the matter minutes is that I am a Benami holder for my husband. This is a plea taken not by me minutes but by the special the authority minutes who has said so. And minutes they have filed the petition before the court. Now kindly see minutes for one moment. Section 3(2) of the Act minutes. I can take your lordships to the petition there itself minutes. I've extracted running page 53 for a moment.
We'll look at the act itself.
Please.
Act is here. Yes, appointment of register, yes. Yes,
Not attachment of properties not on default of return of deposit starts at section 3.
mm,
But
yes,
please, minute. But just before that, minutes for one moment, just to have that clarity, since
it's not Money Lenders Act.
it is not money lender.
Karnataka depositors,
Oh. I'll hand over this minutes. This is okay.
oh, yes.
I'll hand over this.
Yes, it's there.
It's there.
Mm. 3, attachment of properties.
Please, minutes. Now, before that, minutes, section 2(3) deals with depositor. Means a person who has made deposits with a financial institution. It may establishment. It could be any sort of establishment. Now, minutes.
You're relying on which definition?
Minutes. I'm just pointing out who is a depositor, what is a financial establishment, all these parts. Just for
There are definitions.
yes, minutes. Section 2.
Who is depositor?
Yeah, 2 minutes. Subsection 3 is a depositor. A person who makes a deposit with a financial establishment. What is a financial establishment? Minutes is explained in 2 subsection 4. Not it could mean anything almost. Group of means any person or a group of individuals.
You're reading which provision now?
Yes, minutes.
You're reading which provisions?
Minutes. I'm so sorry. The section 2.
Section 2 is definitions.
Yes, subsection
subclause,
4
sub-
there minutes.
Huh?
Subsection
4.
yes.
Yes. Yes.
3 only says depositor means any person who makes a deposit in a financial establishment.
Yes.
4 minutes says what is a financial establishment.
Yes.
Minutes 4 says any person, group of individuals accepting deposit under any scheme, arrangement, or in any other manner, but does not include a corporation or a cooperative society owned or controlled by any state
Yes.
government
Yes.
or central government
Yes.
or a banking company as defined under section 5C of the Banking Regulation Act 1949. This was a bank. Whatever we were dealing with, which has gone bankrupt, is a bank. So the exception to financial establishment, minutes 2(4) is found, which may have to be dealt with, not because whether this bank do come under KPID Act, I may not be concerned with it, not stricto sensu. For me, minutes, I am only to show that I have nothing to do here. Now, minutes, kindly see. Attachment of properties are dealt under a separate chapter, chapter 2, which starts with section 3 minutes. The government or district magistrates in the respective jurisdiction, suo motu, or based on market intelligence reports, or police authority, on receipt of any complaint, may cause investigation of a complaint or fraudulent transaction referred to in this section through its functionaries, collect the information regarding the properties and money believed to have been acquired by any
Straight
financial.
away come to 6, section 6.
Minutes 3(2) might have some bearing.
I've seen that.
3(2) minutes.
Yes.
3(2).
Yes.
Minutes. Ultimately, minutes. I would only have to do something with minutes subsection 3 there,
Yes.
where the government is satisfied that such financial establishment is not likely to return or make a payment or other benefits assured or to provide services.
You're
Deposit.
not concerned with that also because you're nothing.
No,
to do
minutes,
with-
I am not. This is
So
where,
you are concerned with section 6, come to section 6.
I'll just come down to 6.
Yes.
Duties and powers of competent authority. On receipt of order of appointment, the competent authority may take such necessary actions as it is necessary for expedient to take physical possession of all monies, assets, and of the concerned financial establishment expeditiously, and the competent authority shall have powers which are necessary for the aforesaid purpose, without prejudice to the generality of powers vested in subsection 1. Competent authority may carry out the purposes of this act and shall be entitled to require police assistance or any other authority.
Skip it, you can skip it, that's not
That is
necessary.
also not required. Open bank accounts in any scheduled commercial bank and credit all money.
Also not
That is
necessary.
also require any person.
C is what is relevant.
Please note, require any person believed to be in possession and control over money or assets of financial establishment to furnish necessary information and to hand over possession of such assets to the competent authority and shall comply with the requisition. Now, minutes, what happens after this, minutes says, they will make an attachment under subsection 1. Competent authority, minutes, the functions are in section 6. Minutes, the attachment goes back to section 3(1).
No, what I'm trying to
Yes,
tell
minutes.
you is that you fall under 6.
Minutes.
No, you have nothing to do with the establishment.
I'm not
Your
doing-
husband was a director of the company, and at a relevant point of time, he has purchased a property for a consideration of 40
have
lakhs and odd. Now, for you to say
Yes,
that my husband has nothing to do with this, I have on my
not my
independent.
husband, minutes, not my
No,
husband.
that's what, on my
Me.
independent income, on
Yes,
my,
yes,
on my
ma'am.
own, I
Yes,
have
ma'am.
purchased
Yes,
a property.
Yes, minutes.
For that, what is the evidence that you have placed before the court?
Minutes, now kindly see, there is no inquiry which has been held, which is what I wanted to point out.
No, first of all.
Yes, minutes.
Prima facie, that's the court says that
Yes,
it
minutes.
is, it is
We have
the
placed
property.
statement of
You are a
objection.
benami on part of, you are
Yes,
holding
but
that
in
property.
extenso, minutes, we have filed a statement of objection.
Let's see that now.
52 minutes.
Yes.
Minutes, we have raised.
So before going to that, let's complete the order.
Yeah, I'm sorry.
To the
Yes,
order.
yes, minutes. Now, minutes, the order,
Contention of the respondent number 2 in brief.
brief minutes.
Please
Re-
read that.
Respondent number 2 in her objection denied the entire petition government. It is stated that the interim order of attachment passed by the government is not in accordance with law. Apart from the same, competent authority has filed this petition on 24/1/2024 after 35 days from the date of the notification in contravention of section 3 of the act. This with respect to the statutory limitation self-contained within the act. As such, the petition is not maintainable. Since the revenue secretary has not authorized the same to be filed, this petition after 30 days, the competent authority did not follow the mandatory guidelines to pass an order of interim attachment. Thereafter, she referred to the proviso to section 3 of the act, contending that only if the competent authority is satisfied that in case of insufficiency or unavailability of funds with the institution, then the personal assets of promoters can be touched upon. The state government, before issuing the notice, will have to tender figures with assets and liabilities of the financial establishment and then come out to attach the property. Notification herein is absolutely silent about the aforesaid details. It is further stated that the respondent number 2 is neither promoter, partner, director, member, or any other person of the financial establishment, that without ascertaining that the properties of her proceeds of crime or derivatives of money siphoned the attachment without any basis. It may not be grammatically all right, but the essence is, I am not either one of them. And the act mandates it is only one of these people.
No, when you
This
put-
petition is filed after a lapse of 30
Correct.
days and it is
When
barred
you
by
can-
law.
When you can say so many things,
Yes,
you should have as well said, this
it is
are
my property.
No, these are my income tax returns. This is how I purchased the property. One simple line could have been
We have
sufficient.
stated that.
Why did you say so?
4C for
Simply
the
you said, you
4C
are not, what are the documents filed before the
22
court?
minutes. 20.
I'm looking at that. I
Yes,
read
minutes.
that.
This is exactly. Minutes.
Ah.
Minutes, I am pointing out, we never reached the stage of an inquiry because minutes, we were arguing on the preliminary objection. Whether minutes, I am entitled to be prosecuted at all before the court. Minutes, I am pointing out minutes, this. Minutes, kindly see. Minutes, the authority files some petition. Minutes, it has not laid in evidence at all. It has not laid in evidence at all. No, we have gone in on a very preliminary framework, not whether, and not unfortunately, since summary procedure relatable to CPC order 37 is applicable, not the trial court has the special court has gone in on the framework saying that one need not have to lead evidence at all. This is how the order has been passed. My IT records are there. It's a matter of record, and I've pointed. That is why.
Averment. Where is the averment in your?
In 4C, the averments are extracted. I'll just point out to the relevant, the statement of objections are also there along with the.
Come to that.
Please, running page 58 for a moment.
Yes. Where is it?
The last 4 lines. The attached property in question is brought by the respondent number 2 of her funds derived by
Reading
running
it, page number
58.
58.
58.
Ah.
Attached property in question is brought by the respondent number 2 out of funds derived by running a travel and logistics concern in the name of Mrs. Nirmala Enterprise. The copy of letter appointment salary shall be and bank balance sheet shall be produced separately. Now, this is where I have stated that I have separate income. I have separate income. What we wanted the court to decide was on this premise just 2 pages before that. I have just extracted, I have bifurcated the section. 55 for a moment. 55 for one moment. This is the very same framework of the section is sought to be extended. for one moment, 55 minutes.
Not 55, para number 5 of page number 23.
Please.
Though the respondent number 2 has filed objection, she has not sought for any permission to defend the case as required under so and so and has not opted to place.
This is contrary to records because minutes, my statement of objections is filed.
Objections filed, court
Yes,
also
minutes.
agreed
This
that you have not let any evidence.
minutes, is it not that the petitioner will have to, or minutes, kindly see, at some point of time, minutes, must there not be minutes a procedure for posting the matter for evidence? I'm just pointing this to myself, minutes. Even in the summary suit procedure, minutes, once leave to defend has been granted, leave to defend stands granted and objections or written statement is taken on record, minutes. There starts an inquiry where issues are formed and minutes, respectively, the court will say either plaintiff can lead evidence or defendant has stated so and so, so he shall lead evidence.
Yes.
This stage has not come, minutes. Your lordship may verify the order sheet. There is no stage of evidence at all. Kindly see, minutes, for one moment. If my lordship sees the act, it says summary procedure. That is minutes attributable to order 37. This is not followed. The court minutes did not post the matter for evidence at all. Minutes, the 12.5 for a moment, minutes, is where the procedure has been defined within the act. 12.5 of the act minutes defines the procedure there. Minutes, if I fall within this definition, minutes, I think prosecution minutes on the jurisdictional fact is valid. If I'm not minutes, it is not. May just one indulgence minutes for 55 for a moment. There's absolutely no reason specified minutes or tendered that I am the Benami of Mr. T.S. Satyanarayan.
It's for you to prove.
Minutes, this is reverse burden minutes. That is not what the act may say for a moment. That is what the petitioner says for a moment. And this is a volatile legislation, not that burden is on them. The burden to say that it is definitely myself.
You've been given an opportunity.
No, I've been given an opportunity to defend. I filed my statement.
2019 was your purchase.
Please,
That's the time where all these things have happened.
not exactly minutes, 2020 or 21. 20 and 21, these things start happening. My husband also passes away.
Was a director in 2019 when this
Yes,
property was
he
purchased?
was. Ipso facto minutes, will that be an aspect? That is. There is no presumptive jurisprudence under that act, not for a moment.
No, you have been given an opportunity.
Correct, minutes, there is an opportunity, but the procedure is not followed. Lordships may have the records, and I can just point out from the e-court records minutes. There is no, the order sheet does not show that the matter stands posted for evidence at all. You argued on the maintainability of the petition minutes because the maintainability issue was under dispute. Very. Yeah. Session special. 470. Oh. Hmm? Okay. It's not a problem, no. Nirmala.
When is the order of attachment?
No, sir, this order of attachment not,
Interim order of attachment.
not, one moment, I'll just give the interim order.
Date
No, it is 23/12/23 minutes.
Yes, please take out notice.
I shall not, in the interim number, the only request what I am requesting, minutes, this will have an effect of auctioning of my property. Kindly see, minutes, this is the finding ultimately. And why we are before
Within a-
this court,
within a
such hurry,
week-
minutes, is
Within a
this.
week, you please take.
42
notice.
minutes, 42 for a moment, public auction.
No, within a week you take.
I'll take it out today itself,
Let them
that's
come.
not the point. But minutes, at any point of time, there could be a public auction.
When
Once
is the-
public auction
when
is
the
done,
impugned
minutes,
order?
out, minutes,
When is the impugned order?
minutes, this impugned order is 22/7/24.
When is this with this MFA?
Minutes, this 20th of August 2024. Minutes, whatever time minutes we get the certified copies, minutes, as instantly minutes we are there before this court. The point what I'm trying to make out is this, minutes, let there not be
The submission
precipitative
of the
auction. I will not
counsel
be.
for the appellant, they shall be stay of all further proceedings. Pursuant to the order dated so and so, so and so. Till September 18th.
Please, I'll take out.
By the time, if the petition is permitted to take out a notice on the counsel appearing for the respondent before the trial court. And shall file a memo shall serve a notice to the special public prosecutor. And shall file a memo to that effect by 13th of September. If the memo is not filed by 13th of September, the stay granted by this court shall stand vacated without further reference to the court. If the memo is filed on 13th, list this matter on 18th.
Cell number 27.
Respondent 2 will not notice could be dispensed. I'm not.
Who is respondent number 2?
That Soharda Cooperative Society Limited.
If you say that it is not required, you file a memo
Please, minutes, if
To the
need
pub-
be, I will do them.
to the public prosecutor.
I'll,
as well
or
as
minutes,
the respondent 1 and 2, both.
please,
Yes.
all.
Cell number
Because
20.
respondent number 2 was not represented before the trial. So I might have to take,
No, that's why you have to say that and file a memo.
please,
That
or
will
I
be
will
taken.
just take process in the usual course for the respondent. I'll do that part because respondent number 2 is unrepresented before the trial.
Yes.
I'll take process in the regular.
Notice to respondent number 1,
Please, minutes.
special public prosecutor.
Yes, minutes.
Yes.
And notice by regular means to.
Summons, hand
Summons,
summons.
okay.
Yes.
Number 27.
Please, my lords, for the
20.
respondent, my lords.
Prasanna Kumar P.
Yes.
Lords, the criminal miscellaneous application, my lords, filed by the petitioner before the London Magistrate Court, my lord, has been dismissed. And she has deliberately not appeared before the court. And thereafter, my lords, during the
And when that happens.
this, my lords,
13.
13/8/2024, my lord. Yeah. 2 weeks ago. my lords. Previously, my lords, the conduct of the petitioner, my lords, may kindly be looked into. Despite of taking 8 adjournments, my lords, before the trial court.
No, why the court, why it is stated that she is not in a position to even move?
That is a submission, my lords, made by the petitioner.
Petitioner is currently incapacitated due to rheumatoid arthritis, which has severely affected her mobility. Bed rest to manage her condition.
Previously, my lords, they had filed 3 applications, my lords, for maintenance during the pendency of the criminal miscellaneous application. All 3 application, my lords, came to be dismissed. The learned magistrate, my lords, had a categorical observation stating that despite of petitioner working, she had filed a false affidavit before the court. That is a categorical submission, the categorical observation, my
They're
lords,
raising out of what?
CMIS, criminal miscellaneous application.
You're saying another
During the
2, 3.
DV proceedings, my lords, similar applications for maintenance was filed. That came to be dismissed, my lords. Subsequent to that, my lords, the petitioner approaches the learned family court. During the pendency
That
of
order
MC
passed in the
proceedings,
DV with regard to her
maintenance,
maintenance was not questioned.
that was not questioned, my lords. And my lords, there was also a categorical observation that how as to unauthorizedly she had withdrawn an amount close to 14 lakh rupees, my lords, from the respondent's account.
There is that order.
That order, my lords. That order, my lords, I'll produce it. That there is a categorical observation with respect to that. And
What is happening?
The Domestic Violence Act is entirely different proceedings.
Entirely different. There is a the reliefs that are claimed in the Domestic Violence Act are independent and unconnected with any other relief. They can claim, there is no dispute about it. Now, a competent court has given a finding saying that she do not require maintenance and dismissed her application.
That was challenged.
That is challenged.
That is what challenged.
What has happened to that?
That is still pending.
Notice has been issued and they have been appeared.
And what do you say about this? Have you seen this?
No.
Give it to him, a copy of it.
my lords, this honorable court, my lords, was pleased to direct. This honorable court, my lords, was pleased to direct the learned trial court, my lords, to conclude the proceedings within 6 months in the writ petition order, my lords. Despite of that, my lord, the same, my lord, she is filing one more application with respect to maintenance. Previously, my lords, from the year 2016 till date, my lords, whenever the matter is listed for evidence, the petitioner, my lords, comes and makes a submissions with respect to she is ready to settle the matter, let the matter may be referred to mediation. During the course of mediation, my lords, they do not cooperate for the settlement. Once the file, my lords, is returned from the mediation center to the court, then they file one more application, my lords, stating I need maintenance. Evidence, my lords, my evidence has been concluded, my lords. I have not been cross-examined till date. The respondent's evidence, my lords, has been closed thrice. She has filed application subsequently for reopening. After reopening, my lords, they don't cooperate in the trial. Such being the conduct of the petitioner, my lords, I am unable to proceed with the trial.
File all you file your objections with all these details.
Previously, my lords, I filed my
Objections are filed.
objections are filed, my lords.
In this
The
revision.
new developments.
Yeah, subsequent to it, this I'll file a additional, my lords, a rejoinder or a memo.
In this review petition.
Review
You
petition.
come
I'll
up
file.
with all those grounds,
Please.
what all you are saying, with all those orders and serve a copy on them.
Please.
So that they'll get an opportunity to.
Please.
Yes, at the request of land council, the respondent, when can you file?
1 week.
Post this matter on,
Meanwhile, my lords, let them proceed with the trial, my lords. They are filing one more application.
that day we will pass all the orders. 12th of, post this matter on 12th of September.
My lords, may I request some date before 12th, my lords? The matter before the trial court is on 12th.
Post this matter on 11th.
Yeah.
By 10th, you file your by 10th, the objection shall be filed. A copy of that shall be served on the council.
Not 11th, my lord, 10th, my lord.
10th,
10th.
yes.
Great.
Objection shall be, but then by 9th you have to serve your objection.
Please, my lords.
Please.
Yes. Yes, 27.
Grateful.
Bill number 28. Rajesh Shankar Gaur Patil. Rajeshwari Shankar Gaur Patil.
No representation, non-filing of complaints report by the advocate for petitioner. No representation. Pose this matter on behalf of both the parties. Pose this matter on November 12th. Yes, next.
Bill number 29.
29.
I appear for the respondent.
I appear for the petitioner, my lord. In this case, my lord, the maintenance of petition filed by the me was partly allowed. That is, maintenance was rejected. Only educational expenses of my son was granted, my lord. And your lordship may kindly, I'll just read out my translated copy I filed, my lord. I'll just read out the facts in issue, my lord. The facts.
What is the maintenance sought for by the wife?
Maintenance sought 20,000 for the first petitioner and 10,000 for the second petitioner, my lord.
That is the son or daughter?
That is the son, my lord. He is he's the
Aged?
student. He is studying in law.
Aged.
He is now studying in law, my lord.
He's studying law.
Studying law,
How
my
much
lord.
the court has granted?
For educational purposes, my lord, only, lord, one second. Only education work. It not there is no quantum. Entire educational expenses must be borne by the respondent, not maintenance. Maintenance for both the.
So no other amount is granted towards
No
maintenance.
other,
only
no other
entire
amount. No other amount.
education expenses have to be borne.
Only educational expenses.
What is the income of the husband?
Income of the husband, my lord, as per me, my lord, as per my,
Reduce it. Yes.
he has got the property and
Reduce some more. Yes.
he has the agricultural land at Madhapura village and residential house and residential Ramanalli village, and he's having monthly income about more 50,000, though he is sufficiently capable of taking care of himself, having enough source of income.
What is the wife doing?
But actually, my lord, wife is now doing nothing. Actually, in the beginning, she has a beauty parlor. There also, he drank and came out there, made all mischief, and he made me to close down the beauty parlor. Now I am nothing. I am totally depending on my parents.
Please come to the order. Come to the order.
No, my lord, just may I read out my pleadings, my lord. That is
No, not required. Come to the order. Please come to the order.
Right, my lord. That is a translated copy I furnished, my lord.
Where is the translated copy?
May I read from para number 13 onwards, my lord?
Where is the translated copy?
Translated copy separately I furnished, my lord. Because it was in Kannada, so separately I filed. As per the direction of this honorable court.
Yes.
From para 13 onwards, I mean, read, my lord.
Start from the reasoning, para number 10.
Okay, right, my lord. Para number 10, my lord. According to the details in the petition, since the respondent completely neglected petitioner, for which petitioner number 1 started beauty parlor by borrowing loans. Even after that, the respondent who used to drink come near beauty parlor and behaved immannerly, for which most of the customers stopped visiting the beauty parlor, suffering from financial clog, she started relying on her deceased mother. While this being so, during COVID pandemic, she left respondent and returned to her own native and started residing there itself, wherein respondent completely neglected to take care of the petitioner. The respondent denied all these points and stated that since he became deaf and was incapable of continuing his driving profession, and hence he set up a beauty parlor to the petitioner number one, and petitioner number one, who started having income from the said profession, used to have inferior attitude against the petitioner who is deaf and completely neglected him, and then she expelled him out of the house since had no income, and at present he is living under the shelter of his mother. Both the parties produced several evidences before the court in order to substantiate their arguments and objections. Among them, only few reliable evidences are taken for examination. Para number 12. It is undisputed fact about the relationship between the parties and that the petitioner is residing separately from respondent. Exhibit P1, Exhibit R5, invitation, Exhibit P2 and P6, photos are 8 birth certificate of the petitioner's notice are all also undisputed and are supplemental to this case. Though it is the stance of the petitioner that the respondent himself abandoned this house and have neglected her, the supplementary evidence to prove the stance of PW1 are not available before the court. Also, any factors admissible for the allegations are not brought out in the cross-examination of RW1. In Exhibit P14, diverse notice issued by petitioner number 1 to the respondent on 28/12/2018, it is alleged that the respondent has caused physical and mental torture and abandoned her. But the document marked as Exhibit P15 as regards to the discussion permitted to petitioner number 1 by Mysore Women Police Station on 9/12/2018 and excluding the medical certificate marked as Exhibit P18 issued by the medical officers of Primary Health Care Center on 22/12/2018, and that she took treatment at Primary Health Care Center at Hale Agrahara on 10/1/2018, that her husband had assaulted on her about 3 days ago. There are no other documentary evidences before the court to conclude that the respondent has caused harassment on petitioner number 1 during the period of 16 years of marital life between petitioner number 1 and respondent. Moreover, PW1 herself during the cross-examination has adduced that she is not ready to live with the respondent. When all these factors are carefully examined, it could be concluded that there are no enough reasons to show that the petitioner number 1 is not capable of living together with the respondent. Hence, as provided under section 125 clause 4 of Criminal Procedure Code, it could be seen that the petitioner number 1 who is living separately from respondent number 1 is not eligible for culminating maintenance from him. Moreover, the important point to be noticed here is that the petitioner number 1 has filed MC number 214 of 2022 before the so-and-so court, Mysore, against respondent seeking divorce. The said case was transferred to this court and the same was simultaneously inquired along with this court, and the said divorce case was ordered, under which petitioner number 1 got divorced from the respondent. Despite there are no documents in this court, the said fact may be considered by the knowledge of this court. Hence, as explained in section 125 of Criminal Procedure Code, the petitioner number 1 does not come under the purview of wife, but she comes under divorced wife. And hence, though the divorced wife being petitioner number 1 has no source of income and the respondent is well stable in terms of income, if she proves that he has denied to take care of her and has neglected her, and then she would be eligible for maintenance from respondent till her remarriage or lifetime.
No, while granting divorce, permanent alimony is not granted.
Not granted.
Yes. What do you say, counsel for the respondent? What is this finding of the court that even after divorce also she is not ready to stay with her husband? That's why under 125(4) she is not entitled for maintenance. Unmute your audio.
My lord, may I be permitted to argue this matter on Monday? Because
were
I'm
you
not.
doing? What were you doing till now? When the court is spending this much of time, we should have asked it in the beginning.
No, my lord, it's not like that. He has raised few points which I have to answer. I'll answer.
All waste of court's time. Pose this matter on 12th
On
of September.
10th, my lord, on 10th, I'll
10th
physically
is not
come.
possible. At the request of counsel for the respondent, please don't do that. When you're not ready, please tell that you're not ready. Unnecessarily, court would have taken 20 minutes of the court time is wasted.
Still,
On 10th, which is the date, my lord?
12/9, sir.
Obliged.
Hearing B group, serial number 30. A.S. Naresh. Santosh for petitioner. Bopanna B.
I appear for respondent.
Any interim order in this?
My lord, there was a direction to deposit 60% of the.
On that condition, stay is granted.
Yes.
No representation on behalf of the petitioner. Poses matter for dismissal on 12th.
Serial number
Yes, ma'am.
31.
See, there is an interim order in this. Next matter, 31, any interim order?
There shall be a visitation.
Interim order is there. You that. No representation on behalf of the station. No representation on behalf of the petitioner and counsel for the respondent is present. Pose this matter on 7th of November.
Serial
Yes.
number 32. Rangaramu B.
Appearing for respondent, madam. Petitioner have not served the entire petition copy in this case.
Any interim order in this?
No interim
No
order.
interim order. No representation for the appellant. Counsel for the respondent is present. Pose this matter on 4th of November. Yes, next.
Sorry, 4th of November. Serial number 33.
Hearing for the petitioner.
Prasanna VR.
In this matter, my lord, the other day, this honorable court has directed to produce the declaration affidavit filed before the trial court, my lord. I have applied for the same before the trial court, but I have not
have
yet
sent
received it.
She has it.
I'll file it in the register or I can give it now. Let's.
You have a copy of. Password
Any other day, my lord.
12th.
Great.
At the request
For
of the
submission,
counsel.
my lord, I am ready to take the respondent and wife, children, child back, my lord.
Also that, find out from your client what is
I'll
the,
find out what is.
it is submitted that the petition is ready to take back the child and the wife. Then counsel respond and get instructions in this regard. Was this matter on 12th? Yes, next.
Serial
Instead
number
of 12,
34.
may I seek for a week, my lords, instead of 12th, 14th or some, 13th or.
14.
Great.
Yes.
Serial number 34.
Appear for the petition on the last date of hearing, your lordship directed that summary of the bank details should be furnished pertaining to the.
We'll take up this matter after lunch. I think for dictating the order and all, it will take time after lunch.
Yes, please.
Next matter.
Serial number 35. Revana Siddhappa. For petitioner.
That
Ravi.
is a counsel for the petitioner.
There's one submission, please. Filed my statement of objections. Matter in the trial court, the trial is concluded. Both petitioners have led evidence in chief and cross-examination is also concluded. Now they've challenged for enhancement with a delay of over a year. The order was of 2000, March 2023.
Who appears for the petitioner?
I'm for the petitioner. I'm for the petitioner. my lords.
Uh,
This
No,
petition is,
no, the main, that itself is, no, the main trial itself is concluded now. Now, what is this application at this stage? Let the court decide your entitlement in the main application itself.
my lords, honorable trial court has granted meager interim.
Court now in the final argument, let that be decided by the court, whatever arguments you want to.
That matter was
Sub-
posted for respondent petitioner evidence, my lord.
Uh,
It was posted for cross-examination.
Which year is this MC?
22. ma'am.
22. ma'am.
If I may submit, there are multiple matters. ma'am. There's 125 petition is also pending. That is being, the trial is held separately.
My lords,
And
this is-
DV Act has been filed in 2024.
He is totally neglecting the petitioner, my lord.
How much the court had granted?
6,000, my lord.
What is the income of the petitioner?
50.
The respondent,
He's,
According to
he's
them,
a
the-
businessman, my lord, a rice
according
merchant.
to him,
According to him, my lord, he
according to him, how much is the income? As per the statement of assets and liabilities,
approximate 1,50,000 is monthly income, my lord.
as per the assets.
Pardon me,
Yes.
ma'am.
He himself admitted in his cross-examination, my lord. Kindly see Annex D, my lords.
I'm.
Annex
producing
D.
Tell the court, what is that?
This is certified copy of the
What
assets
did
and
you say?
liabilities.
What did you say?
The cross-examination produced by them is 15,000. I will read it out, please, Ma'am. It's in.
He
Kannada.
himself
I believe
admitted
you
in his
want-
cross-examination, my
No,
lord.
in your statement.
Kindly see Annex D, my lords.
Please wait. In your statement of assets and liabilities, what did you say? That's.
I'm producing the.
Tell it, tell the
15,000,
court,
please.
1,500.
Yes, yes, please. And the cross-examination portion which is produced by them at Annex D also reflects the same.
But
please.
he falsely stated, he
If you falsely state something, then that
My lords.
an inquiry has to be done in that.
he-
How can the court say that it is, he has falsely stated?
in the cross-examination, my lord, he admitted his income. He is a businessman by running a rice merchant.
How much is his income as per the cross-examination?
Specific admit ಮಾಡ್ಕೊಳ್ಳ, but he is a businessman earning,
No, please understand.
he is running a school from first standard to 12th standard, my lord,
Your
aided school.
assertion about his income is not sufficient. Now, as per the judgment of the apex court, both of you have filed your statement of assets and liabilities. As per that, according, he says that it is 15,000. According to you, it is not correct. You have to file some document or some other evidence you have not filed. So how the court can say that what you say is correct and what he's saying is wrong?
We'll have it next week, my lords. My senior will come argue the matter.
Matter can conclude before the trial court in next week. It is already posted for if there's
Who's this
any.
matter on the
Next
top of the list on 14th of August?
If convenient on the 12th. week.
On 12th of September.
Great.
Pleasure, for pleasure.
I'm also producing the assets and liabilities for the convenience of the. I've served a copy,
Registration is filed.
register.
Cell
Yes.
number 36, Muniswamy Gowda.
Senior is arguing a matter in other.
Pass over. You have other matter also?
Yes, my lord.
Passed over matter.
Yes, my lord, last time your lordship has directed the parties to furnish that video recording
Huh.
of that CCTV.
It's not filed.
My lord, they are not providing because I have sent mails to them to the.
No, the wife
association.
is in the same, she should do it.
I have also sent a mail. They say that there is no court order, we will not punish you. Get
Why
the,
the court, there should be an order to them.
the association is saying that, like, I sent a mails to them.
Hmm.
They are saying that,
You
you,
will pass such an order.
yes. And so far as the 230 matters.
2:30, we'll pass the same order at 2:30.
Grateful.
Yes.
Cell number 37 for dismissal, SJ Sangvi.
Pay for the appellant.
Yes.
Yes. It's a case
Effect
of,
of 2014.
yes, ma'am.
Abhinay Vaiti, respondent.
I pay for Mr. S.J. Sangvi for the appellant in this case.
You have a stay in this?
No, my lord.
No interim order?
No, it's a matter arising out of a railway.
Oh, it's a railway claims tribunal. I was under the impression that it's a CPC matter. What is the order?
The order, my lord,
I think in all these matters, he's appearing, what is his name?
Abhinay,
No,
Mr.
central
Sang.
government is appearing.
Yes, my lord.
Shanti Bhushan is appearing. Inform him, we'll take it up in the afternoon.
I'm not having his number, my lord. I'll try to find out because I am coming from Hyderabad, my lord.
No, you can ask
Just
anybody.
ascertain from my friends.
They'll have a chamber here. Yes,
Please.
pass over.
Please.
Yes, next.
Cell number
I appear for respondent number 13.
For the
I'm
petitioner,
on behalf of
kindly
respondent
pass
number
over.
20, my lord,
Senior
sir.
is-
Request for a pass over.
Pass
Please.
over. Yes.
Please.
Okay.
39.
Cell number 39, Narendra Gowda.
Local Adalat has been fixed on 14th, my lord.
Uh-huh.
For local Adalat, it has been fixed on 14th of this month.
This matter is before the
Yeah,
Lok Adalat.
yesterday there was a meeting with
It is submitted that the matter is before the, why is this listed here?
this, last time it has come up before this court and I took the time to file a additional document.
Hmm.
That's why it has been
No, if
attached.
you're saying that Lok Adalat, this matter has to be there.
This LIC matter, they directed to post before the Lok Adalat.
List this matter before the Lok Adalat.
On 14th. 14th of
To be
this.
held on 14th of September. Yes. This is directed to place this matter. Yes.
Cell number 40. Cell number 40, VN Puttalingaya.
No representation. Pose this matter on behalf of both the parties on 5th of November. Yes, 41.
Cell number 41. MJ.
In the judgment, my lord, the amount is wrongly mentioned, my lord.
Let's see that. Why so early you are filing this petition?
No, my lord, I filed long back, my lord. 27/5 I filed.
So what is, according to you, what is wrong?
Page number 3, my lord.
1 minute. Page number?
3. my lord. Item number 5, my lord, that is the.
Loss of income during later period.
That should be as 20,000, my lord. This is the amount awarded by the tribunal, my lord.
1 minute, 1 minute. Attendant transport 20,000, 10,000. Loss of income during the later period. It is, court has taken it as 36,000.
Yes, ma'am.
Why it has come as 5,000?
No, my lord. No, my lord. Before this amount, my lord, is the compensation awarded by the tribunal. That was wrongly typed, my lord.
No. There will be a slip like this. Court slip is there. What is the calculation that date is made?
But the total compensation is correctly mentioned, my lord.
Uh,
There is no dispute about it.
No,
Only in respect of
one
the
minute,
amount.
1 minute, let me see. Bindia. Order of Bindia. Pain and suffering 60,000. Medical expenses 1,19,325.
Yes.
Attendant
10.
No, you are referring to what was in the.
Tribunal, my lord. Tribunal,
Oh,
not by the honorable
So
court.
loss of income should be how much?
20,000, my lordship.
20,000. Yes, that will correct.
Yes. 6,
Then-
my lord. Item number 6, my lord.
Loss of future
Future
earning.
income, that should be as 9,45,000. That is mentioned at
9 lakh?
45,000.
Hmm.
And total should be, my lord, 12,19,325.
19,000. Even in the calculation also it is written 12,19,000.
Yes,
That's awarded by the court.
But that
12,19,325.
325.
Yes, this will be corrected.
Yes,
Then,
and page number 7, my lordship.
yes.
Paragraph 8.
Hmm.
Accordingly, the appeal is allowed in part against the compensation from, my lord.
That also should be.
That should be.
changed. That is 12,19,325 to 18 lakhs.
That is
2,000.
correct, my lord.
Ah.
That is correct.
That's the only.
Yes.
That's the one.
No, even if it is cut and paste, it should be right. Because from the trial court or whatever is there in the order,
Perhaps they are.
then at least if she followed this also, everything is written on this paper. This court by order dated 21st March 2024 has partly allowed the appeal. Now the petition is filed before this court seeking correction of the judgment. It is stated that at page number 3 of the order, in the table at column number 5, loss the court has given a table how the compensation is awarded by the trial court. In that, the loss of income during the later period, it is mentioned as 5,000, but in fact, it is 20,000. Then coming to the future earning capacity, it was 9,45,000, but it is mentioned as 9,000. And the total compensation that was granted by the tribunal is 12,19,325, but it is wrongly mentioned as 2,68,325. And the same mistake is carried in para number 8, where the court has observed that the appeal is allowed in part, enhancing the compensation from rupees 2,68,325 to 18,02,825. He submits that it should have been enhanced from 12,19,325 to 18,02,825. The learned counsel for the respondent is also present. He also does not dispute the fact. Considering the same, at page number 3 in the table, at column number 5, it should be in place of 5,000, it should be 20,000. For our column number 6, it should be 9,45,000. Then and the total amount should be 12,19,325. And at para number 8, instead of 2,68,325, 12,19,325 shall be shown. Accordingly, the corrected copy shall be uploaded. Please.
Serial number
Uh,
42.
Can show this to that India. Such a blatant mistake.
42, I'm up here for the petitioner, madam. Kindly pass over, madam.
All the pass horses have to be argued. No adjournment again in the afternoon and no request for further pass overs in the afternoon. I'm telling all the advocates.
Please.
Yes,
Attend 44.
yes.
44. Sagar V. Shastri.
For the petitioner, your lordship, husband's petition challenging the order passed in criminal misdemeanor.
Notice is not ordered in this.
Okay.
Notice to the respondents. Petition is permitted. No, that's RPFC, no? Notice to the respondents, post after service of notice.
Lordship,
Bill
I've
number
also
45.
filed for
Huh?
a stay. I've also asked for a stay of the impugned order.
What is the order of the trial court?
Directing me to pay interim maintenance of 6,000 to the wife, your lordship.
6,000 to the wife. And what is your income?
25 to 30,000, your lordship.
And then why can't you pay the 6,000?
I have some miscellaneous expenses that happens.
What about her? I can
Yeah, yeah.
understand some exorbitant amount is granted. We'll see. Yes. Notice 45.
Serial number 45. Hegde Ramakrishna S. For the petitioner.
Pass over some memo is moved. Yes, 46.
Serial number 46.
Hmm. Delay of 163 days.
Yes,
Notice
Your
has to go.
Notice already been, they have taken notice.
Oh, somebody is appearing.
Yes,
Pass over?
yes.
Yes, 47.
Serial number 47.
For respondent number 1.
Bharatnath.
In this matter, you appear for respondent.
Filed application for amendment, my lords, wherein they sought to amend the prayer with respect to one of the proceedings has been disposed of. However,
No representation for the petitioner post this matter for dismissal on 12th. Yes, 48.
Number 48.
Counsel for the respondent is present. It's 48.
48. Ananya Rai.
Pass over it. It's already 1:30.
Yes.
Yes.
Lordship, may I make on submission, Lordship. Serial number 10, Lordship, the matter, I kindly apologize, Lordship, when the matter was called. Lordship, kindly permit me to take answer, Lordship, in serial number 10.
In all that 10, what has happened, hand summons?
Notice has happened, Lordship.
10, 1 minute, what is the matter?
Is an
10,
standing counsel is a Lordship. I will,
MFA of 2022. Hand summons.
any date may fix, Lordship.
Yes. That usual dates we give. That's taken by Bindia, I think. You only took? You already. Which is the number?
38.
2838. No, it's 2603. It's already signed. You can prepare one more and well. Yes. Send them all of them. Whenever I say this notice, let it be hand summons. Then all of. Oh. In which case? Then in that case, Neil, then post it. for
Number
some other
submission.
day. Don't look at it. Hmm. 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 Remove from dismissal. Give the same date. No dismissal on the same date.
So number submission, serial number 47, my lordship.
No mentionings, nothing at this
No,
time.
no, my lordship is given for 12th, my lords. May I request for 13th?
Yes.
47.
Great. 13.
Dismissal ಇದೆ.
13.
47 ಏನು? 47 ಇದೆ, no representation. 12th ಇದೆ, 13th ಬೇಕಂತೆ. 13th ಹಾಕಪ್ಪ, dismissal ಅಲ್ಲೇ.
13th ಅಂತೆ. ಬರ್ಕೊಂಡ್ರಾ?
47, 13/9 ಬರ್ಕೊಳ್ಳಿ. ಆಮೇಲೆ ಇದು ನಿಲ್ಲಿರೋದ್ರಲ್ಲಿ ಬರೀ ಡೇಟ್ ಕೊಡಿಪ್ಪ.
ಯಾವ್ದು 14?
ನೋ ರೆಪ್ರೆಸ್ ನೋ ನೋ ಇಲ್ಲಿ
Madam, serial number 15.
14
ಹೌದು 14.
ಅದೇ ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿದೆ, ನೋಡ್ ಬೇಡ. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್
ಕೊಡ್ತಾರ
19/9 ಮಾಡಿ. 19/9 ಕೊಡಪ್ಪ.
ಯಾವುದು
14th ಎಲ್ಲ ನೋಟಿಸ್ ಆಗಿರೋದ್ರಲ್ಲೆಲ್ಲ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಂತ ಹೇಳಿ.
ಅದು ಡೇಟ್ ಕೊಡ್ಬೇಕಂತೆ. ಡೇಟ್ ಕೊಡ್ಬೇಕು.
ಅದನ್ನೇ ಬೇರೆ ಬೇರೆ ನೋಟಿಸ್ ಇಸ್ ಆರ್ಡರ್ಡ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಅಂತ ಹೇಳಿ. 10 ಅಲ್ಲಿ ಡೇಟ್ ಯೂಶುವಲಿ ಕೊಟ್ಟಿದಾರಲ್ಲ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್, ನೋಡಿ ಅದು
ಕೊಟ್ಟಿಲ್ಲ.
ಯಾವ್ದಕ್ಕೂ ಕೊಟ್ಟಿಲ್ವಾ?
ಮೇಡಮ್
ಅದೇ ಒಂದು 15 ದಿನ ಬಿಟ್ಟು ತಗೋ. 15 ದಿನ ಬಿಟ್ಟು ಕೊಡಿ.
ಮೇಡಮ್ ಪಾಸ್ಪೋರ್ಟ್ ಎಷ್ಟಿದೆ?
Permitted to take out hand summons and to file a memo ಅಂತ ಹೇಳ್ತಾರಲ್ಲಪ್ಪ. ಆ ತರದಲ್ಲಿ ಒಂದು 15 days ಆದ್ಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಅಂದ್ರೆ 15 days ಆದ್ಮೇಲೆ ನಿಮಿಷ ಇರಪ್ಪ. ಆಗಸ್ಟ್ ಇವತ್ತು 20
ಅಲ್ಲ, ಇವತ್ತು ಇದು 4/9 ಇವತ್ತು.
4/9 ಅಲ್ವಾ? 15 days 18/9
Memo.
memo to be filed and take up time summons before to the advocate appearing before the trial court and to file a memo to that effect on 18/9. If that memo is filed, this matter on 19/9. ಅಲ್ಲ 230. 50 ಕಾಲ್ ಔಟ್ ಆಗಿಲ್ಲ ಬಿಡಿ.
ಆಗಿಲ್ಲ. ಮೇಡಮ್
ಎಲ್ಲ ಮಧ್ಯಾಹ್ನ.
ಪಾಸ್ ಓವರ್ ಎಷ್ಟಿದೆ?
ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್, ಎಣಿಸಿಲ್ಲ.
ಅಲ್ಲಿ ಎಲ್ಲ ನೋಡಿ ಡಿಸ್ಪ್ಲೇ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಎವ್ರಿಥಿಂಗ್ ವಿಲ್ ಬಿ ಡಿಸ್ಪ್ಲೇಡ್ ದೇರ್. ಹೌ ಮೆನಿ ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ಸ್ ಇನ್ ಅವರ್ ಕೋರ್ಟ್, ಎವ್ರಿಥಿಂಗ್ is there. If you gone through it, you will comes to know how many matters are passed over in our court. Still rising even after lunch hour also, it is my business is to file this. They'll not come when the case is called.
230 list.
Number 3.
Yes.
Case number 3, non-compliance, CL number 1 for dismissal, Prashant PR.
What about it? The other list also at 230? No, yes. Give that. In spite of lapse of 4 months, when the appellant has failed to comply with the office objections. The matter is posted before this court. When this matter came up on 3/9/2024 before this court, as there is no representation on behalf of the appellant, this matter was directed to be listed under the caption for dismissal. Today also, there is no representation on behalf of the appellant. It appears that the appellant is not interested to pursue the matter. All this, 1 to 5,
CL
1 to 5, dismiss,
CL
for non-prosecution. Yes.
6 to 10 answer.
6, 7 till
10.
10. Yes.
11 disposed. For orders matter, CL number 12. SR Egda Udlamane, CL number 12.
Hearing for the appellant. Lords, seek to apology, my lords. We informed the appellant as soon as the order we got from the paper publication. Due to his ill health, we could not take the action on time, my lords, as your lordship has directed. I request one more chance so that we can take the appropriate publication in the paper, my lords, as your lordship for the last date of hearing.
No, if he's not interested, why?
No, my lords, he was sick, so he could not come to office, and for the paper publication. necessity of-
2014, appeal is of MFA of 2014.
Yes, my lords, I understand. lords.
What remains in this appeal now?
Suit, my instructions are that, my lord, suit is still pending.
There is any stay in this?
I don't think so, my lords.
Then what is the relevancy of this now? We'll hear it. Pose this matter on 12th for 12th.
Please. my lords.
CL number 13. Nagaya.
Appear for the appellant in this case, my lords.
Yes,
Lordship had heard me with respect to the valuation is concerned, my lords.
not heard.
My
Have to
senior,
hear. No, your senior also not heard.
please, my
You
lords,
have to argue.
please. Heard in part, my lords. But what has happened here is the respondent has raised the contention that the valuation which has been made is not proper. The Lordship may please take up page number 79, my lords, of the appeal. This is the order of the reference court, where the court has held that the difference amount is 9,46,342. Upon which, my lord,
Enhanced to compensation is 9,46,342.
342. That's upon which, if your lordship may please take up the valuation slip, which is at page number 17.
70.
17. So the award of the SLAO, that is a land acquisition officer, is 36 lakhs 92,123. And the award of the reference court is 46 lakhs 38,465. And the difference amount is 9 lakhs 46,342, to which the additional solatium at the rate of 30% and 12% has been added. And the court fee of rupees 84,000.
When you file the suit, how it is valued?
This is how it has been valued, Manoj, under section 48, please. So when it is added, Manoj, it comes up to 14 lakhs.
14 lakhs.
39,322, for which, Manoj, the court fee of rupees 84,092 has been
This is
paid.
the amount you are seeking.
Please,
Enhancement.
this is the enhanced amount on which I have come on an appeal.
So, no, when you sought for enhancement of 14 lakhs 39,000, court had granted 9,46,342.
Well, so I am the beneficiary, Manoj.
You are
I'm-
the beneficiary.
I am the
They are
beneficiary.
questioning that order.
Please.
Hmm.
So this is the case, Manoj. So according to section 48 of the Court Fees Act,
So you're aggrieved as far as this enhancement of 9,46,342 is concerned.
but section 48 reads as follows. The fee payable under this act on memorandum of appeal against a decision or an award or order relating to compensation under any act for the time being in force for the acquisition of property for public purposes shall be computed on the difference between the award amount awarded and the amount claimed by the appellant. So accordingly, Manoj, the court fees has been paid, and even in spite of this, Manoj, the previous officer also made an impression that on the previous occasion, that is on that is on date 9/7/2024,
You mean to say the
court
What?
order.
the learned judge?
Please, Manoj.
Yes.
Well,
Pay-
it says that learned counsel for the
Date,
respondent.
what is the date of order?
Well, it's on 9/7/2024.
9/7/20.
2024.
Hmm.
The learned counsel for the respondent has drawn attention to this court to memo filed on 2/4/2024 and order of even date would submit that the respondents are disputing memo of valuation by appellant and alleged payment of the deficit court fee. Though dispute regarding the valuation of the court fee is raised,
Yes, sir.
registry had not raised any contention with respect to this. This is my submission. Manoj.
Yes.
Court fee paid is
My lord, your lordship may kindly see, my lord, I have produced since there was some mistake, my lord, in the order produced by my friend, I produced the.
This is the order.
Yes.
Hmm.
Your lordship may kindly turn to, my lord, the amended. award.
Now, he's the beneficiary.
Yes.
He is aggrieved by enhancement of the compensation by the court. He is only questioning that. Is there any dispute on that?
My lord, there is a dispute, my lord. Total amount, my lord, which has been awarded is 1,34,79,180 dollars.
Where do you get that?
Lord, 59 of that certified form. My lord, in page 59.
I'm looking at that.
My lord, the award with statutory benefits calculated at rupees 35,25,576 plus 99,53,605 is equal to 1,34,79,181. Is payable by the respondents to the petitioner by way of enhanced compensation with interest bill realization thereof. From the date of victory after the date of deposit, together with the court costs as per the memo of cost given below. Then, my lord, in the previous page, your lordship may.
What is the enhancement?
Enhancement, my lord, total award passed by the LAO is.
No, not the LAO. No, he is only, no, the reference court had enhanced the amount.
Yes.
They are only aggrieved to that limited extent of enhancement. So let's only go to that. He's only except to that limited extent.
these are the statutory.
That,
Pre-decision.
take that.
These are just the statutory benefit that has been awarded by the court, Manoj, but there is no definition which says that we have to pay the court
Let's see,
fee.
let's, what is,
Please.
yes,
Last decision.
Indo Development Authority,
Page 22, my lord.
page 22.
Yes. Karnataka Court Fee and Suits Valuation Act 1958. My lord, your lordship gets the relevant provision, my lord, at page 24. Para 5. If the provision of section 48 of the act had remained as it was, the contention of Sri so and so would have been an exception. But the explanation has been added to section 48 to the act by Amendment Act 80 of 76. That is subsequent to the full bench decision. Section 48, together with the explanation as it stands after the amendment, reads as follows. Fee from memorandum of appeal against a decision, award and order. My lord, that I may skip my explanation. For the purpose of this section, the expressions amount awarded and amount claimed include any other additional sum payable in accordance with the law providing for acquisition in consideration of the compulsory nature of the acquisition. According to the main section,
the court fee has to be paid on the amount claimed in the appeal. If we read the section together with the explanation, it clearly means the appellant in an appeal under section 54 of the Land Acquisition Act.
So according to you, apart from that, the solatium and other
has to be-
incidentals have also to be calculated, and basing on that, the court fee has to be paid.
Yes, this is followed by and two more division bench judgments, my lord.
No, we'll conclude this judgment, please.
My lords, it has been paid, my lords, as.
Please wait,
Please.
yes. According to the main section of.
According to the main section 48, the court fee has to be paid on the amount claimed in the appeal. If we read the section together with the explanation, it clearly means the appellant in an appeal under section 54 of the Land Acquisition Act has to pay court fee on the amount claimed in the appeal, which includes not only the additional market value claimed in the appeal, but also statutory allowance, in particular solatium payable under section 23 of the Land Acquisition Act. Then, my lord, para 7. My lord,
Yes.
once again, section violate of so and so, so and so. Then, my lord, court fee on solatium also. My lord, next is decision, my lord, is at page 1. This is by Special Land Acquisition Officer versus
Yes.
so and so. My lord, your lordship gets this para 4 and 7.
Para 4,
Para 4 and 7. And 1 second. my lord.
page number, you have given the page numbers.
My lord, page 4, my lord, the first contention. My lord, regarding middle, my lord, your lordship gets regarding first contention. Section 48 of the Karnataka Court Fees and Suit Evaluation Act, so and
Oh,
so.
that is extracted,
That is
then
extract.
Indo Development Authority is.
Development, my lord, is referred. Then, my lord, your lordship
Come.
may kindly go to page 7, bottom, my lord. My lord.
Page 7 or page 6? I mean,
Page
para
6,
6.
it is relevance. The regarding second content, the appellant contends that this appeal is not filed by the beneficiary, but filed by the Special Land Acquisition Officer, who is an officer of the state government. He relied on section proviso to section 4 of the Karnataka so and so, which reads as follows. The appellant contends that this court, relying on the second proviso of section 4, has already held that appeals by special LEO or KIDB were exempted from court fee. He relied on the order of the court fee dated so and so, passed by the division bench of this court in so and so. The said order extracted below. My lord, the first paragraph your lordship may skip, second paragraph. The scheme of section 28 of the Act, unlike that of the analogous provisions of the Bangalore Development Authority Act 1976, suggests that the acquisition is initiated in the opinion of the state government. Any land is required for the purpose of development by the board or any other purpose furtherance of the objections of the Act. The state government may by notification give notice in its intention to acquire such land. The provisions of section 28 clearly points to the acquisition being made by the government itself. Both the notifications under subsection so and so of section 28 are issued by or at the instance of the government. Provisions of section 8, subsection 8 are indeed clinching.
Yes, I've seen that.
Yes, ma'am. So, my lord, a distinction is drawn between the appeal filed by the Special Land Acquisition Officer and SLAO on behalf of the board. They hold that, my lord, if it is on behalf of the board, the court fee is required to be paid. The lords may kindly go to para 9, my lord.
That I have read the judgment. I've read the judgment.
Yes, my lord. Then Indore Development Authority, my lord, I need not trouble. Next judgment. Then the third judgment, my lord, is at page 14, para 5 and 6. My lord, once again, my lord, section 48 is extracted. Para 5, my lord, is important. A plain reading of the above provisions would no doubt prima facie create an impression that liability to court fee on the memorandum of appeal will arise if the appellant before the appellate court makes a claim for payment of compensation over and above the amount awarded by his favor by the land acquisition officer. A beneficiary of an acquisition cannot, however, make any claim for payment of any amount in his favor, either before the reference court or before the appellate court competent to hear the appeal. It is, on the other hand, can challenge the correctness of the order passed by the reference court, granting enhancement the compensation awarded to the owner. Strictly speaking, therefore, Mr. Rao's contention that the liability to pay court fee does not arise in the case of appeal preferred by the beneficiaries of acquisition could not be lightly brushed aside. The same effect indeed was a division bench of this decision so and so, executive engineer versus so and so. That case dealt with section 40 of the Act
before its amendment and held that the word applicant appearing at the end of the said section clearly implied that liability court fee will arise on the claimant owner seeking payment of compensation. The legal position, however, undergone the change since the pronouncement. The issue was examined by the Supreme Court in Indore, so and so, so and so. Then, my lord, finally, para 6. I can skip, my lord, the page.
Yes.
The only difference between section 8 of the Madhya Pradesh Court Fee Act and section 48 of the Karnataka Court Fee and Suits Valuation Act lay in use word applicant in the Karnataka Act instead of word appellant in Madhya Pradesh Act. The Karnataka Act was, however, amended by section.
Yes, I've seen the other judgment also. The next one on in Ram Jose versus Ramakrishna.
Yes, my lord.
Yes.
Then finally, the correct position after the pronouncement of the Supreme Court is that even on appeals preferred by the beneficiaries against the order made by the reference.
Yes.
Court fee is payable on the amount that represents the dispute differential.
Yes, yes.
So on.
Yes, Mr. Kant.
That's at page number 86
Of what?
of the appeal memo, my lords.
Oh.
The judgment of the reference court.
Yes.
But the court has categorically differentiated the award with statutory benefits, which can be read in section 48, which says that, my lords, the amount for the court fee has to be computed with respect to the difference, upon which the 30% solatium has to be added and 12% interest has to be paid.
Explanation.
Lords,
Explanation to the provision.
please. Please, my lords.
Hmm.
For the purpose of the section, the expression of amount awarded and amount claimed include any other additional sum payable in accordance with law, providing for acquisition in consideration of compulsory nature of the acquisition. Plus, for which we have also paid the 30% solatium and 12% interest, upon which we have paid the court fee, my lords.
If you are paying, where is the dispute?
The dispute is with respect to the respondents are concerned, my lords.
No, that you're there. No, your argument was
Please.
you are liable to pay the court fees on that 9 lakhs, which is enhanced by the reference court.
Please.
You have not added all the solatium and other things.
No, sir, it has been added, my lords.
If all that added, how much it comes to?
It comes up to 14 lakh, my lords, which can be seen at the valuation slip. At page number
What is the
17.
dispute if that is also added?
My lord, that is not correct. I have read your lords, my lord, the last one.
Even for a figures also, why is this confusion?
Total figure is 1 crore plus, my lord. It is not 14 lakhs.
For a minute, my lords.
My lord, if your lords.
So 1 crore plus is what has been, including what has been awarded by the LAO.
It's minus, my lord. What has been awarded by the LAO
Please
is
come to that again. Please come to that. You are referring to 17.
Lords, please, page number 17, my lords. That is the
Please come
valuation.
No, first come to 17 and tell the court how it is not right. 17 of the appeal memo. 17 of the appeal memo. What is wrong in it?
That's the para number 6, my lords.
My lord, award of the reference court. My lord, there is some.
Let us open this also. Let's see what is the difference between that and this.
My lord, your lords may kindly see amount from page 17. Amount awarded by the reference court, land, 2,09,715. My lord, there is no dispute with respect to that.
Yes.
There is no enhancement. Compensation for fruit beer increase, 34,82,408. Enhanced compensation for trees, survey number 77. My lord.
No. A and B, it remains to be the same as awarded by the LAO.
Yes, my lord. It is 35 lakhs something, my lord. There is no difference. Here, there is some calculation mistake, my lord, I understand. My lord, the calculation mistake may be minor, maybe 1 lakh.
That you leave it. Now, next comes is enhancement. They
Amount
say
awarded by SLAO, respondent number 2, land. Land, there is no difference. Compensation of fruit beer increase.
also it according to you is a matter of 1 lakh.
Then difference is, my lord, 9,46,342. That, my lord, my learned friend deducts from serial number 2 minus serial number 4.
The serial number 1.
To arrive at 9,46,342.
Why is it wrong?
My lord, that may not be wrong.
No. So, no, let the facts be clear. Now, as far as this enhancement of 9,46,342 is concerned, There is no dispute.
Yes, my lord.
Hmm. So how much is the solatium added to that amount?
My lord, 30%. My lord, I'll do.
30% is how much?
Your lordship may have it tomorrow instead of wasting your.
No, no,
That's-
no tomorrow. This has been
Now,
so
my lord,
many
your lordship may
tomorrows.
kindly go to page number 4, my lord, of the award, which I furnished to your lord.
That is filed by you.
Yes, ma'am. My lord, that is a certified copy.
Yes. Yes,
My lord. My lord, enhanced award 9,46,000.
yes,
Then solatium 2,83,000.
yes.
Then my lord, total 12,30,000.
Hmm.
Interest from so and so, my lord, 1,10,000. Interest on additional market value, 1,47,000. Interest after expiry of 1 year, my lord, 20,36,000.
Total it comes to 35,25,576.
Then awarded passed by the LAO, my lord, 36.
No, that you forget. No, on this he has to pay the court fees.
Then, my lord, there is some mistake. Interest, my lord, subsequent interest is added. Interest from 28/11 to 2010 to 29/11 is 4,31,000. Additional market value, my lord, 12%, 5,75,000. Interest after expiry of 1 year, my lord, 79,47,217.
Please understand, whatever he is entitled till the reference, till the reference court has awarded the compensation, that's not, we are not going to calculate on that. No, the difference is 9 lakhs, enhancement is 9 lakhs. On that, whatever the solution, whatever the interest, whatever other things, basing on that, he has to pay. That will clarify. Let's not waste further time. Please come.
But at page number
If
7,
he has paid on that, let it be.
My lord, it is not paid, my lord, it's my submission.
it's at page number,
No, it should be paid on this.
The registry calculated that, my lord.
Yes, on the registry shall calculate on the enhanced amount of 9,46,342, whatever solatium, interest, whatever comes, basing on that, he has to pay the court fees. If he has already paid the court fees, it's fine, otherwise he'll pay.
Please.
Yes. Please come. Caller, is it coming? This appeal is placed before the court on the submission of the counsel for the respondent that the court fees paid by the appellant is not that is sufficient court fees is not paid by the appellant. The appellant before this court is the beneficiary. The reference court had enhanced the compensation as from that is granted with LAO is 9,46,342.
112, my lord. Total.
112.
112. It is 38 lakhs 1,370.
Where is that 112?
I pass on. my lord.
And which is the page?
that is, well, it's at page number 112. This is the award of the land acquisition officer, my lords. I don't know
It's not
what's wrong with
complicated.
this, my lords.
Let's not complicate it.
My lord,
No, there are admitted facts. No, how are you bothered, first of all?
my lord, he is required to deposit, my lord, as per the division bench, 50% of the awarded amount. My lord, here, not 1% is deposited. My lord,
Then you have to argue on
But this
that.
amount has already been paid to him, my lords.
Not that.
Please let the court pass order. I heard the both of you. What did you write? Not the LAO, the
ಅದು
reference
ಹೇಳಿದ್ದಾರೆ,
court
ಗೊತ್ತು ಬಿಡಿ,
had
ಹೇಳಿ.
enhanced the compensation to which page is that? That calculation, has enhanced the compensation to 9,46,342. Agreed by the said enhancement of the compensation of 9,46,352. agreed thereby, the beneficiaries before this court. They have paid the court fees. Where do you get that? On what amount you have paid? Where did you
Page
say?
number 79.
Page number?
79.
17.
It is stated that for the purpose of jurisdiction before this court, the appeal is valued at rupees 14,39,323. A court fee of rupees 84,092 is paid. Land counsel for the appellant submits that they have paid the court fees as per section 48 of the Karnataka Court Fees and Suits Valuation Act 1958. And the objection by the respondent is without any basis. He submits that, in fact, the registry has not taken such an objection. Next paragraph. Land counsel appearing for the respondent had drawn the attention of this court to section 48 and explanation. And basing on that, land counsel submits that for the purpose of computing the court fees as per section 48, the expression of amount awarded and amount claimed include any other additional sum payable in accordance with law provided for acquisition in consideration of the compulsory nature of acquisition. According to him, the amount is 1 crore and odd, and on that he has to pay the compensation. He has to pay the court fees. He had drawn the attention of this court to the judgment of the apex court and Indoor Development Authority. It was reported in 1995, supplement 3, so SCC 225, and also a judgment of this court wherein following the judgment of the apex court and Indoor Development Authority has taken a view that while computing the court fees, all the add-ons also have to be taken into consideration. He had relied on the judgment of Special Land Acquisition Officer versus Gadada Vanu and others reported in ILR 2000 Karnataka 3527. For the similar, and also he had relied on the judgment for the purpose that even if it is a beneficiary, still they have to pay the court fees. He has also relied on the judgment in case of Konkan Railway Corporation Limited versus Special Land Acquisition Officer 2 and another reported in ILR 2004 Karnataka 231. And also another judgment in Ramaya versus Special Land Acquisition Officer ILR 1992 Karnataka 2193. Basing on these judgments, land counsel submits that the court fee that is paid is an insufficient court fee, and he has to pay the court fee according to the petitioner, according to the respondent, on an amount of rupees 1,34,070, 1 crore 34 lakhs 79,181. Next para. Having heard the counsels on either side, this court has perused the award passed by the reference court. There is no dispute about the fact that the reference court had enhanced the compensation, and the enhanced compensation is 9,46,342. And for that, the solatium at 30% and additional market value at 20%, 20%.
That's 12%.
12% per annum, and the claimant is entitled when an appeal is filed in the light of section 28 and explanation to section 28, section 48, explanation to section 48, they have to pay the court fees on that enhanced amount coupled with the interest and the solatium. The registry shall calculate the same, and if the petitioner and the petitioner has to pay the court fees on the same. If once the court fees is paid, the MFA be listed for admission.
My lord, in this matter, office has accepted the valuation and received the court fee of 84,000.
Anyhow, again, let's not go back to that. Yes, next.
There's an interim order, my lord.
Interim order all you granted is extended till then. Yes, next 14.
Cell number 14.
Have it, my lord, after 1 or 2 weeks, my lord. Last will get it order to this, my lord, after 1 or 2 weeks.
Why? It will come immediately once. Your apprehension is that he will not pay.
Not that. No date is given, my lord, it doesn't come. Getting listed is.
Yes, pose this matter on 24th of September.
Please.
By the time, if any deficit court fees is there, has to be paid.
Please.
Yes, next.
Cell number 14. Ketan Yadav, steps to be taken in respect of this. Refused R80, R38.
Notice to R38, returned as refused, amounts to deemed service of notice. Next, for furnishing of PF for issuance of notice to R3, R5, R8, R10, 12, 13, 15, 18, 19, 27, 37, 39 shall be paid within a period of 1 week, or else the appeal stands dismissed as far as the said respondents are concerned. Yes, post this without further reference to the court. Finally, a week's time. Yes, next.
Cell number 15.
Right.
Non-compliance of office objections.
There's one small issue still, my lord, with respect to the schedule. While the schedule is taken on the basis of the survey numbers, which is there in the plaint, the office says you must state the name of the person in the schedule in the plaint exactly because they are no longer the owners today.
What is that? Please, now, the following office objections are yet to be complied.
Yes,
As per Annexure D, defendant number 23 stated to be deleted,
yes.
whereas defendant number 23 of trial court has preferred this appeal memo clarified.
My lord, what happened was before the appeal was filed, this, my lord, is a second round of the litigation. Suit was decreed, went up in appeal. We were,
No, first of all, whoever are the parties to the suit or the IA, they should also be shown here
yes, they all
as the
shown.
parties.
Yes, yes.
Then if you are not seeking any relief of any.
No, no, they're all shown. I am defendant number 23.
What it says that it is deleted.
At one point in time, my lord, in the suit, when the suit was present before the appeal was filed, at that time he was deleted. And then he was restored back after the appeal.
You also have to restore.
I'm restored.
Huh.
And
What is the clarification?
the court, my lord, sees one order sheet where it is shown as deleted and then says you're deleted. How are you filing the appeal?
That is there, but where he is restored again?
Yes, my lord. That
No,
order
the
is
order
here.
impugned is shown as a party?
Yes, yes. It says defendant number 23 argued. Everything is done.
Yes. 23 said to be declared, the next necessary application to be filed with regard to appellant herein, what is of trial court?
That is not saying if you want to file an appeal, you must file an application for permission to file an appeal. But that is not there because the order itself shows me as the opponent here.
Details to be correctly stated in appeal memo.
Beg your pardon?
The schedule details to be
Schedule
correctly.
details, that's what I said, my lord. The schedule in the plaint and in the appeal are the same, except for the one change. At the time in 2003, they indicated the name of the owner at that point in time in the schedule. Now, my lord, those persons are not the owners, but the survey number is the same. That we've pointed out in the schedule.
No, where is impugned order? Let's see.
Yes, my lord. Lordship may see the impugned order, my lord, is at Annexure A, page 23.
No, as per this impugned order,
Yes, my lord.
court had considered which schedule of
There's
the
only one
property.
property. There's only one property.
One property, same, whatever are the,
Same.
whatever are the boundaries, whatever.
Boundaries are the same.
That you also see
That
here.
we have said.
So,
The problem, my lord, is in the plaint.
no, the registry is not the court that where it will understand.
That
And
is
that too in a civil proceedings, you can't tend to submit something else before this court as far as that basic cost title, the boundaries. If you want any clarification, that should be done before the trial court.
Not that, my lord. When in 2003, the boundaries.
No, even if you change here.
I can add it, my lord.
That remains to be same there.
Yes, it
Please
will remain the same. We'll add that, my lord. We'll add that right now. My lord. Lordship may permit us to add it right now.
Yes,
We'll add it. That's the only thing, my lord, which is left.
yes.
May I just point out, my lord?
Yes.
We've served a copy on the Caviators Council as well.
Where is he? Name is printed.
Parashuram R.
Probably he's thinking that it is coming up for non-compliance of office objections. We'll have it on Tuesday.
On
Do
Tuesday.
the petition is permitted to.
Tuesday.
The petitioner shall comply with the office objections, post this matter on
Tuesday,
Tuesday.
okay, no?
No representation for the respondent caveator.
We'll correct the schedule. if-
Yes.
Great.
Give them. Next. Await service of notice. Appear for the respondent.
I think, sir.
What is your name?
Weeks time may be gone.
So and so submits that he has instructions to file wakalat. Pose this matter on any interim order is there in your favor?
No, the application.
Matter on 18th of September. Yes, next.
Then number 17.
In this case, Lord.
Hmm.
Petitioner is the mother. In the GNWC case before the trial court,
Hmm.
certain,
What is that?
Copy not.
I have received
No,
now.
1 minute, rectification of office objections raised on statement of objection.
Now I have
Yeah.
received, yeah.
Rectification of office objection, yes.
Not receive that. Because it becomes infectious.
So you will go ahead with the case.
It's,
Let's see what is the impugned order. What is the impugned order?
The matter is simple, my lord. Mother, petitioner is the mother.
Please tell the court where is the impugned order.
My lord, impugned order is page number 34. Ink page number 34.
You are appearing for the father.
Mother, before the
Appear for the
trial,
mother.
mother, I am the
Ah.
mother. And the child is about 14 years. It's in the custody of father.
So
There
what
was
is-
ambiguity in the order, my lord, that every alternate month, second Saturday, in the presence of police, was the direction given by the trial court. Therefore, this honorable court,
So the parties are compelling the court to pass these kind of orders.
no, both of us are not aggrieved about taking the child with the help of the police.
So what?
We have never said.
This is the only clarification you want.
No, therefore, yeah, for that reason. But alternate month, it's been saying every alternate month. Therefore, I appeared before this honorable court.
Why the daughter is with the father? Why the daughter is with the
No,
father?
son, my lord.
Son is
Yeah.
with the father.
My lord,
GNWC
it is
is filed in
the marriage
2021.
has taken place in 2009. After so much of length of marriage, on all of a sudden, I was thrown out of the house. A petition under section 10 of Hindu Marriage Act was filed, seeking judicial separation with an IA restraining me from entering my own house. When I want to see the child, then they are showing the order that there is a restraint
When
order.
was this?
This was filed in the year 2021. That was the initial order. Now, by virtue of passage of time,
GNWC is filed by you.
therefore, I filed a GNWC. And
Matrimonial cases are pending.
no, so far not. I have filed a section 9 petition before the trial court and it's pending. I wanted to restore the marriage. He wanted a judicial separation.
Where the father is staying and where the mother.
Both of them are in Bangalore, my lord.
Hmm.
And
Why
by
this order of 2 weeks? 1
mother
year?
seeing, my lord.
Yes.
Because he is in 10th standard. And he is also good at sports. He is representing state in all the events, especially karate, shooting and swimming. He is selected for national event also. Because of this order, and there is a order by the trial court saying that he should not be shifted or without the permission of the court, he cannot participate. So every time you have to seek permission.
Why such an order is passed by the court?
They have thought, they have filed application.
Then why did you not question that order when it is passed?
I have filed vacating also. Till today it was pending.
He has not challenged it before this honorable court in any petition.
Selected for the national event, I have to seek permission.
No, it's wrong, my lord. There is no such order passed by this honorable court.
Now just I said that I don't want to press that. That is also same. He was selected for national team in Delhi.
He is referring a trial court order, not here. This court has not passed. IA number 1 disposed by this court, it may kindly be perused, my lord. IA number 1 it was during the last time.
Orders are passed. How can, why should the permission of the court be taken when he's participating in any of the events?
No, I have not made any such attempt, my lord. I have not made any.
It's like the
If
court
the
has
child
passed.
goes, I am happy. I'm happy that my child is going out of the, I have never bothered about it.
Now, if that is so, if the court is not vacating that order, you file an application before this court, the court will deal with it, number one. Number two, why the mother should see the child 2 weeks or 3 weeks, once in 2 or 3 weeks? What is this? We'll pass an order. Every week she'll exercise her visitation. Is a boy of 14 years?
One thing. He is also attending the sports event.
Let him attend.
So from he is in 10th standard and he is going for a tuition also.
Spending time with the mother will make him do good in his academics also.
2 months alternative month, let it be every month.
My lord, I am a mother.
It has to be once in a week.
One submission, my lord. Under similar facts, may I submit?
He cannot come and he morning.
He need not come. She will go and meet him wherever he is.
His school is starts from
Weekend.
9 o'clock to, and every Sunday he is attending the sports coaching, karate, shooting, and also.
And let it be. Yes.
I will take the child.
12 o'clock to 5.
Mother will take him.
Yes, I'll accompany the child. Wherever the
Mother will
child
take
tells.
him to all those on weekends, whatever he is attending, she will take him. Yes, please come. The present writ petition is filed. Agreed with the orders passed. in-
One submission before that, my lord. IA number 1 was disposed by this honorable court. Last Dasara, I was given 4 days of visitation. That has been not given to me and they are facing
Now we are
contempt on
on,
this.
this writ petition is on IA number 5.
Yes, my lord.
And then let us only restrict to this.
Yes, my lord.
Yes. The agreed with orders passed in IA number 5 in GNWC number 367 of 2021 dated 13/2/2023. The mother is before this court. The mother has filed GNWC seeking the custody of the minor child who is aged 14 years now and studying in 10th standard.
At that time he was 14.
Now maybe 15.
Now he is 16.
15.
16 in 10th standard, 16 and he is in 10th standard. Now, the petition is filed seeking to grant interim physical custody of minor child from Friday to summer holidays. What is this?
No, because even for summer holidays and winter holidays, I had sought visitation rights, my lord. Overnight staying.
What is this from Friday to summer holidays?
No.
Saturday and Sunday.
That's what is in the order. Where is the petition filed by you?
There is ambiguity in the order, my lord. Yeah. So what they have done is, my IA is there, my lord.
From Friday to Sunday of every week on the special occasions and festivals. And also on first half of the summer holidays. The family court, the trial court by the order impugned. Has allowed the application partly, directed the mother to exercise the visitation of rights of a minor child in any park or mall of the place of vicinity of the respondent with the help of the local police on any Saturday and Sunday of every alternative month between 2 PM to 5 PM from the date of the order. The respondent father is directed to hand over the custody of the child during exercising the visitation rights by the petitioner mother on the set period. Both parties are directed to communicate each other regarding the venue, dates and time, regarding arrival and departure. The respondent father shall facilitate the custody of the minor child to exercise visitation right to the mother as per the order. Later on, the mother shall return back the minor child to the custody of the father after exercising his visitation rights without fail. Both the parties are directed to maintain peace and harmony during exercising the visitation rights. Agreed with the said order, the mother is before this court. It is a case of it is submitted with the learned counsel for the mother that the mother was forcibly, she was negged out of the house and a restraint order was obtained against her. It is submitted that the order of the court whereby the permission is given, the visitation is given to the mother on an alternative month between 2 p.m. to 5 p.m. is not a well-considered order. It is submitted that without without any basis, court has only granted the visitation, and further it is stated that it should be the help of the local police, which is nobody's case, and such a clause in the order is unwarranted. He submits that the boy needs to have, boy and the mother, both of them needs to have the company and affection, attachment, bonding with each other, which is also in the interest of the minor. And the order passed with the court needs to be set aside. Next, learned counsel appearing for the respondent, father submits that the boy is active in sports. He is representing the state.
State as well as,
He's representing the state, and also he's participating in he's also representing the country. It is submitted that they have filed a petition. The court has passed an order that whenever he's going to participate in any of the competitions, the permission of the court has to be obtained, which is they are facing a lot of difficulties with such an order passed with the court. It is submitted that because of the busy schedule of the boy, it is very difficult for him to meet the mother every day. And the court had rightly passed an order granting a time between 2 to 5 p.m. on alternative months on Saturday and Sunday. And as far as the help of the local police is concerned, they are also not pressing for such a clause in the order. He submits that when the court has imposed such conditions, he has filed a petition to vacate the said order, and the court and so far the said application is not heard by the court. Next, for having heard the counsels on either side, there is a material on record. The boy is now 16 years old, and right from 2021, it's a case of the mother that she has been negged out of the house. Just because the boy is busy and is busy in extracurricular activities, that does not mean that the mother cannot meet him every week. The mother has every right to see the child, and there are no circumstances to say that that it is not mother meeting the child is not in the interest of the minor. There is no material put forth before the court not to pass such an order where the mother cannot have a visitation every week. Then coming to the case of the husband and the father, that an order is passed by the court that every time permission of the court has to be obtained whenever he has to participate in the competitions. It is always open for the husband, father to question the same before this court. Admittedly, so far they have not questioned it, but they have filed a vacate petition before the trial court, considering the overall development of the child and balancing the interest of both the parents. This court is passing the following order. 1, the mother can meet the child on every Saturday, between Saturday or Sunday.
It be on Sunday.
Huh?
It be on Sunday.
Sunday. On Sunday from 10 o'clock to 5 o'clock.
Overnight stay may be granted, madam. She's staying with her parents. Grandparents wants to see, and they don't allow the grandchild to be seen, my lord. Aged grandparents in their last years.
Mr.
So
Counsel,
will they see the
from 2021, till 2024, nothing is happening.
I had to
Over-
file a writ petition to dispose of the
Sir,
application
please
before the trial.
understand, let it go on for a couple of months. Then thereafter, always change circumstances.
Yes,
You can come up with an application. Yes,
yes.
what did you write? Can meet the child on every Sunday between 10 o'clock to 5 o'clock. And the mother can pick up the child from the father's house. And if any other extracurricular activities are there for the child on that particular day, the mother will take him or accompany him to that said activity.
No. He will create nuisance, my lord. If he,
That is
mother
going
will take
further.
and.
There be mother.
No.
No,
No.
not
Mother can,
required.
father cannot accompany.
25, the mother will accompany the child. The father shall cooperate for the arrangement as made by the court. After 5 months, then basing on the change circumstances and how the comfort zone of the boy, the petitioner father is at liberty, petitioner mother is at liberty to move an appropriate application before the trial court for the overnight custody, accordingly disposed of.
Okay.
Cell number 18. Karthik Yadav.
Petition, my lord, needful is done, my lord. I
Needful
served
is
the
done.
copy, my lord. I filed the memo yesterday.
Learned counsel for what is the name of the advocate?
My lord, Srimati Chinmayi,
Hmm.
the learned counsel for respondent before trial.
As per the orders passed by this court, learned counsel has served the counsel for the respondent appearing before the trial court. What's her name? Where do you get that?
Srimati Chinmayi, my lord. Lord, it is in the order passed by the trial court. It is forthcoming in the order, the petition I have filed. At page number 18,
Copy received. At page number 18.
in the main petition, my lord. The impugned order at page number 18. The learned counsel appearing for the petitioner is Mr. Chinmayi.
Chinmay, print the name of Chinmay, CHINMAYEE. Pose this matter. Interim order is there in your
Please,
favor?
there is an interim order.
Interim order.
Please,
Pose this matter on October 15. Yes, next.
my lord, interim order can kindly be extended.
Interim order earlier granted is extended till then. Yes, next.
Non-completion is third time. Cell number 19. Prashant BR.
Give that. Today, about 7 matters filed by the same advocate or dismissed for non-prosecution. Even in these matters also, there is no representation from 19 to 28. Post for dismissal on Thursday, next Thursday.
Cell 9.
Next,
Cell number. Up to cell number 28.
28, 29.
29.
After for the appellant, my lords,
Nayak.
my lords, I filed Wakala last date, my lords, NOC Wakala, that's not been shown, my lords. It's still showing the name of the previous counsel. I'll make sure the office objections are complied.
1 week, finally.
Please. My name.
You already filed
I
wakalat.
filed last week.
Write your name. So and so submits that. He has filed wakalat. Registry is directed to reflect his name in the cause title. Finally, a week's time is granted for complaints of office objections, or else appeals stand dismissed without further reference to the court. Next,
Non-compliance, fourth time, cell number 30.
yes,
Mallikarjun G.
week's time, 4th time means, what is it? Let's see. Before the registry. Came before the courts. Same. Finally, a week's time, default order. 31,
Cell number 31.
yes, for dismissal on 12th,
29.
no representation.
Ah.
Yes, post this matter under the caption for dismissal. Yes, 32.
32. Cell number 32. Vijay Shekhar Gowda.
My lord, I have complied, my lord, all the office objections. My lord, I have also.
Then why are they showing it?
I don't
What are the
know,
office
ma'am.
objections? 32.
Office is repeatedly raising some
Documents to be stitched along with IA 1 of 2024 and to be indexed accordingly. Additional documents to be attested before competent authority. Provision to be correctly stated on IA number 1 of 2020.
I did it, my lord. 1 week.
A week's time is granted. Complaints of office objections. Next.
Bill number 33,
Yes.
Narsim Prasad.
In this case, madam, I partly complied the objections, madam. It's a pay for a week's time, madam.
Finally, week's time default. Yes, next. Call the pass out.
Pass over matters.
List number 2.
List number 2.
List number 2.
List number 2, CL number 2,
1.
1.
This matter was listed about a couple of months ago. But so please to pass an interim order, my lord, directing this is the husband's writ petition. Direction to me, my lord, to deposit 25 lakh rupees. But I have paid 15 lakhs, my lord, and 2 lakhs was paid day before. So 17 lakhs I have deposited. I have filed an application, my lord, to relax the condition with regards to payment of the remainder because your lordships wanted me to prove my bona fides that I'm willing to settle the matter. Your lordship's order says that they are supposed to file a memo before this honorable court with their proposal for a final settlement of all disputes. The order is dated 26th of March 2024.
19th March.
Sorry, 19th March.
When the parties want to amicably settle and when the husband has stated to the court that he's ready to take the responsibilities of both the educational medical needs of the child, the respondent should come up with a requirement and what are the terms of settlement. As the parties can amicably settle the matter and live their respective lives peacefully. Have you come up with any settlement?
I have filed it on the 28th of March. Karnataka.
Lord, there are 2 apartments owned by both the parties.
So, my lord, before that is taken. My lord, there was a direction that the amount is paid before 1st of April. No amount was paid by 1st of April. No amount was paid thereafter either. Your lordship in the last sentence of the order also records that if this amount is not paid, the petition will not be considered. Despite which no amount was deposited in.
No, when this order is passed?
19th March 2024.
19th March 2024.
With the direction that to show his
No,
bona
but
fide
like as per this order, when he has to pay by what time?
by 1st April.
1st April. When did you file that application to relax that condition?
Now,
Much later.
Now. If I may just take your lordship the sequence
On
of events.
17th of August.
Then his bona fides will clearly become patent. Firstly, my lord, he had to deposit 25 lakhs on 1st of April. He did not do so. Despite there being an order that the petition will not be considered if this deposit is not made. So he did not care. Then when I went before the executing court, pressed for attachment of movables on the 24th of April, my lord, at that point, in order to remove the attachment that the court had ordered in the execution, he comes and pays 15 lakhs. Not before this court. Not
When-
by virtue of this.
When did he pay?
24th April,
24th
4th April,
instead of 1st April.
1st April. He doesn't pay, my lord. It's only after the attachment warrant was issued that he comes to pay. So where is his bona fides?
Very well.
Thereafter, my lord, the court then posts it on in the month of June to pay the balance amount. He does not make payment. When I start insisting for another warrant of attachment, then he comes here and he moves this court. And since this honorable court refused to entertain the matter on Friday, on Saturday when the matter was posted in execution, he made a payment of 2 lakhs.
2 lakhs is.
Until and unless the attachment warrant is issued,
What is the order
absolutely no
impute?
response.
What is the order impute?
50,000 rupees per month.
Per month,
Towards
How much?
50,000 per month.
It comes to how much?
36 lakhs, my lord, as of today, I have paid 17 lakhs. Lord, may I make the submission? My son
No,
turns.
first of all, you have to submit, when an order is passed, that
Yes.
you have to comply by 1st April. Neither in the month of April, May, June.
No,
you
April, I
filed
paid. April 15 lakhs was
No, no,
paid.
no. It's not about a piecemeal business. Court said you pay this much. Then by that time, if you're not able to pay or some other compelling circumstances, you should have filed an application. So April, May, June, July, 4 months you wait. In the month of August, you come up with this application.
Yes.
What are the bona fides on the part of your client,
Lord, may I make-
which this court
Lord,
has to
My
consider?
bona fides are these, my lord. Your lordships have recorded, my lord, my undertaking. My client was before the court on that day. My son turns 18 next October. I have undertaken before this court, I will take care of his medical expenses and his educational expenses until, my lord, he attains the age of 25 years. Your lordships have recorded my submission.
Otherwise, my lord, if my learned friend wants me to argue on merits, my lord, I could today withdraw this writ petition, pay the balance, and by next year, October, my lord, my obligation towards my son stops. I'm looking at my son's long-term interest. I have made a submission before your lordship, undertaking, your
Why
lordship, a
would he
record
stop if
undertaking.
it's in the interest of the child, my lord? His stopping would be in the interest of the child.
Exactly, that's why, that is why I'm making this up, my lord. We have 2 apartments. Your lordships asked us to submit proposals, my lord. The response was that to submit a proposal.
What is her?
So we have 2 apartments. The compromise filed before the family court is where we have both of us executed before a notary. 1 apartment she will keep, 1 apartment I will keep. Before your lordship, the proposal is 1 apartment she will keep, 1 apartment I must write away in my son's name. 50,000 rupees per month I must pay towards my son's educational expenses, and I must take care of his medical expenses. Not the order passed.
Let's see where is our settlement file?
Yes.
What was the date of it?
Filed it on 28th March.
Please read it.
Yes. Pursuant to the directions of this honorable court, the respondent herein, without prejudice to her rights, is placing on record the following terms on which she is agreeable for settlement. Arrears of maintenance amounting to 33 lakhs as on March 2024 be paid by the petitioner husband in compliance with the order.
This is something which can be complied. Next, 2.
Husband is to pay a sum of rupees 50,000 per month towards the maintenance of their son, including educational expenses until child attains 25 or completes his education or gets employed,
This
whichever.
clause you are okay with it?
I'm okay with that. I'm okay. Until 25, yes.
You said 25, they are asking
yes.
50.
The petitioner husband has undertaken to bear all the medical.
No, that is 25,000 apart from the education and other expense.
No, my lord.
What?
50,000.
Let us.
Lord, my undertaking before your lordship was, I will pay for his educational expenses.
From this clause, you
Yes.
tell the court how it is acceptable to your client.
No payment of any monthly maintenance. I will take care of the educational expenses and medical expenses, is what I have said.
Yes, next.
Petitioner has undertaken to bear all the medical expenses of the son for his lifetime. In order to ensure there is enough funds available for future medical expenses, the petitioner husband and the respondent wife, who jointly own an apartment at 5F Maple Block, Regency, Pelican Heights, more fully described in Schedule A hereunder, shall execute a gift deed in favor of their son, Master Agastya, with respect to the said apartment. My lord, the reason this clause has been inserted.
This is
No,
unreasonable
my lord,
clause.
let me
in the-
explain. The order for maintenance, my lord, was passed in the year 2020. An application for maintenance was sought in the year 2018. My lord. And this child suffers from a bleeding disorder, my lord. It's called hemophilia, my lord. What happens is when the child suffers an internal bleeding, normally the blood clots. In this child's case, the blood doesn't clot. So there is a profuse internal bleeding. Immediately, he has to be rushed to the emergency and treatment has to be given to him immediately. And he has to undergo certain physiotherapy in order to keep himself fit, in order to do his day-to-day activities. He is not a normal child, which is why we had sought for lifetime medical expenses. We did not seek for any other reason because this child is a special child. In his case, my lord, he may not be able to.
Yes, that I understood, that his lifelong medical
He can't be made to run
expenses.
from pillar to post the way his wife is being made to run, my lord.
Yes,
Today,
next.
my lord, despite there being an order, despite there being a direction, no bona fide is shown at all, my lord.
Next,
It's
4.
only when push comes to shove that this
We'll come to 4. Please read 4.
parties jointly own an
No,
apartment.
this
where
is, I think he has no objection for this.
3.
4.
No
Yes,
objection.
he has no.
4, they have no objection.
5, no
Then
objection.
comes to 5.
Jewelry.
That is also no objection.
No objection.
Jewelry.
6, no objection. 7, no objection. No, with great respect to my learned friend, Lord, what is awarded by the family code is 50,000 rupees for my son's maintenance, educational expenses, and medical expenses. That order is not challenged by the.
What are the educational expenses of the boy?
My lord, at this point, I do not have the breakup, my lord. I can produce the breakup.
Definitely
I
it
don't
will be
know.
more
Not
than
like-
50,000.
No, my lord, this is per month.
No, this is per month. If you add his medical, his education,
Definitely,
it will
my
be
lord.
more than 50 per month.
Which I have brought it, I have agreed with Ms. Lord. What has happened is, in her case,
So put
every
a word
time
to
the
your
child is
client,
in
please
emergency.
make her understand. No, what your client says with regard to her apprehension that he might not, take care of the child.
But so far as bona fides are concerned, I have placed on record a certified copy of a compromise petition filed by the parties before the family court. 42 lakhs, my lord, is what she agrees to receive. One-time settlement and one apartment, no educational expenses, no medical expenses. I placed it on record before your lordship, my lord, along with an application dated.
Because she didn't agree with it. the
I'm sorry,
compromise
can
didn't
can I make my submission, please? When we speak of bona fides, induces my client, my lord, to enter into a compromise. That compromise is recorded by the court. Because of COVID, order is not passed. And now my lord comes up and says, pay.
And you both
My lord,
of you, no, I think you can stop fighting.
Yes.
Now, please tell your client about this clause number 3.
My lord,
And
should
you
be-
also from your side, what is the assurance that you
No,
will
no,
take
one
care?
settlement would be better, my lord, because
One-
he's made to run around.
No.
For money that has been granted to her, maintenance that has been granted to her in the word year
No,
2020,
then
my lord.
you retain that apartment and according to her, you don't have to spend for,
Pay one-time settlement, that's.
and you don't have to spend for his educational or medical expenses. She will take care. Then that is also a fair deal. You can, one-time settlement you have.
I will
for that.
continue. No, if that-
What is that amount for that one-time
My
settlement?
lord, see, by virtue of this, my lord, I think about 2.5, 3 crores, the value of this apartment. Anywhere if he can.
No,
give
he's
me
having,
around,
no, please
let him
understand.
give, let him
No,
give.
he's
me that.
having only 2 properties. One is already given to
My
you.
lord, the other one, I have paid all the EMIs, my lord. That is why he's not claiming it.
No, let her
It is
come
not-
up with some amount, not that.
My lord, the reason she's unable to give an amount, she cannot foresee what could be the medical expenses for for his lifetime today. Because in his condition, we don't know how it deteriorates and what toll it has on him and what kind of medical assistance he
Is
will
it
need.
that you said that you want to take care of the child?
No, I've said absolutely, I'll take care of all medical. Government of Karnataka provides free treatment for people with hemophilia, my lord.
In an emergency, I can't be running around looking. for-
Lord, I've given undertaking, I will take care.
My
I will
lord,
take care of
that
medical
won't happen,
expenses.
my lord, because there's way too much water flown under the bridge in this case, my lord. There's way too much mistrust, my lord. At no point in time, whenever an order is passed by a court, does he obey me? No point in time.
No, that's
Not once. My lord, when the maintenance order was issued below the court, he did not pay. He came here and he undertook to pay 25 lakhs to show his bona fides, which he did not pay. My lord, when the court came to the conclusion, despite, my lord, the last paragraph of that
No.
order clearly
If
says.
not apartment, if you have to quantify it, how much it would be?
I don't know, my lord. I'll-
Ask, get instructions on that. Let him, if it is, how he'll show,
My lord,
whatever.
in her case, in the
Communicate it to
unusual
him.
circumstances of her case, coming to a figure is difficult. Anyway, I will take instruction.
At the request of learned counsel for the respondent, the post matter, when?
Next week.
Post matter
Lord,
on
from the-
Thursday.
Not from the 12th until the 21st, I'm not in station. 23rd, could it be?
23rd is.
23rd?
Post matter on 23rd.
Okay.
By the time the learned counsels for the respondent shall come up with a figure for the complete medical and educational expenses of the boy. Yes.
Obliged.
List number 1, passed over matter, sale number 5.
Now what is the
Sale
sign?
number 5.
In that list, there is one more matter. No, 2.
2 is ordered.
When is it ordered? Oh, that is along with the other matter. Yes. Yes, passed over.
5, passed over matter, Sadevi MP,
Yes,
Gautam Raghunath.
Before we start, I would like to make a submission.
yes.
Let the petitioner tell us as to where the child is. It's been 36 days since the father has seen the child, even over a video call or a phone call. My lords, they give an address.
That's now the court is going to pass order on that.
My lords, I'll just
So
play-
just, you just please tell the court, what are your instructions?
My instructions in respect, they'll have to come up with a proposal, my lords, of maintenance. I will in fact, let them state what, I have already informed my client, whatever they state, we can probably negate and we can.
Yes. What the boy is doing now? He's not studying. Is
He's studying.
What is the school fees and all?
My lord, he is studying in the, what is the school? Vidyasagar School, Preschool, JP Nagar. Along with the assets and liabilities, we have filed the entire school fees for the present year.
How much is the school fees?
3 lakhs per year, my lord. 2 lakhs 25,000 is the school fees. Then books, tuition, uniforms, transportation fees, etc. All that included is 3 lakhs per year, my lord, for this current year. For the school fees. Then there is maintenance also that we have sought for, my lord.
You know, that
Maintenance
maintenance
of
can
4
be
lakhs,
ascertained.
lords.
Huh?
Maintenance of 4 lakhs, they've sought for before the trial court, if I'm not wrong. That's what, my My lord, they should, just
No,
because.
no,
it's
no,
an-
just don't go into all that. Now they say the actual school, what is the wife doing? Mother
She's
doing?
also employed.
What is the mother doing?
She's working as a freelancing consultant, my lord.
How much? she
Fashion
earns per-
technology, my lord.
How much she earns per month?
She started working last 1.5 year, my lord.
What she says, as per a statement of assessor like.
As far as he's informed, she's in fact told him over a phone call that she earns 2.5 lakhs.
This is ours only, no?
Clear that both, if they're working, both of
But
them, they can
we are
equally
not asking maintenance for her. Do not claim. It's only for the child that is
No, no,
claimed, my lord.
that's what I'm trying to understand. Now, according to the statement of assets and liabilities of the respondent, what is his income per
What
month?
is the
Well,
income
his
tax
income
liability?
depends on his
5 lakhs.
project
Will be there,
activity.
So you must have stated something basing on the income tax
eh?
return.
Well, this year, as far as what I've been instructed, his
Income tax
income this
return
year has
will
been nil. And he's in fact awaiting a few projects. Being in the film industry, my lord, it's a decimal graph, ultimately it goes up and down. So that's what it, but he's willing to take care of his son's expenses, we're not
No,
denying it.
let's say this is 3 lakhs per annum.
Per annum.
So 1,50,000
Yes.
by both the parents, because mother is also earning. Then what about the maintenance of the boy? This is a medical, I mean, this is a educational expenses.
What I've been informed is that the school fees, the actual school breakup, the school fees, 1,50,000 is what he states, my lords.
No,
That's
no,
what
no.
he states.
No, no, no.
No, the
entire-
problem
this-
arises
This
here.
is there when he has entire, this much is what has been
What's-
produced because.
Receipts also filed.
Very well. All the receipts are there. And the school intimation is there.
Look at that.
Lord, from the beginning, my lord, even when diaper has to be paid for the child, he has not paid anything. So this,
No, madam.
this has come
Strong.
this much only because we wanted to place on record what is the actual expenses for the child. Not a penny has been paid for the child from his birth.
A different picture is being
No.
altogether projected. my lord.
Whatever both of you,
After allegation.
whatever both of you say, basing on that, the court will not have any picture. Court has its own picture. So please tell the court what the
Ma'am,
court wants to know.
My lord,
Is IA
the
maintained
very
in that
aspect
relaxation?
of this petition being.
No, no, now we'll come to your visitation next. We are on this point of maintenance. Now, 3 lakhs is the school fees. For that, they filed the receipts before the trial court along with their statement of assets and liabilities. Now, because both the mother and father are working, so as far as the educational expenses are concerned, 1,50,000 for 24-25. Let's forget about what is like earlier year. Now, he must have joined this year, 3 years old.
From 3 years, he's
This
going
year.
to school.
Now he's 3 years old.
Now he's joined the school this year, my lord,
So
2023,
that's why
24.
24-25 for the academic year, 1,50,000 for by the mother, 1,50,000 by the
Please.
father. He has to pay. Then what about the maintenance per month? How much? Further minimum thing you please tell the court. Remaining the court will decide. And in this also we'll pass the visitation.
Please, my lords, I'm not denying that. What is the minimum? What is the? How much are you paying? He's been paying 10,000 till date.
No,
He's
is it
not-
so?
I've
No.
shared the press.
I
shared
placed
the-
on record what he has paid voluntarily, he has paid, recently he has paid 10,000 rupees recently, my lord.
Recently, he started paying or he paid only
No, my
once.
lord, on 2/2/2023, he has paid 10,000, 14/3/2023, he has paid 10,000, and April 23, he has paid 10, all 30,000 rupees he had paid. And now another 10 or 20 he has paid now. That is all he has paid so far, my lord,
50,000 altogether.
so far,
Hmm.
after we filed the case. That is one.
According to you, what are the expenses of the child? What did you say so in that?
Now, when we filed this assets and liabilities, my lord, this was filed in June 2023. Lord, his Montessori expenses 22-23 was 41,450. And then again, next year, Montessori uniform book.
The school fees now you forget about, otherwise what you said.
Lord, the other expenses for her, for monthly expenses was coming about, nanny was there, one nanny, 1 lakh for the grocery, and all the other expenses was. Who was the child in there, pardon?
The school that they admitted the child to.
1,38,000
He was never
for the
consented with, he was
child.
never even asked about which school. He was not even allowed to play a role. As to even he should have-
No, we will tell him, let him start
My lord, I
playing
have
the
even
role of a
been before
father.
Family court. I was shell shocked to receive a notice from family court because.
No,
all this
no,
time
no,
this-
no, this court will pass. Let him play the role of a father.
He's been wanting to since the beginning, my lord. He's not been allowed to. But that
That's
is the
what, now
reason
he
why-
will, he'll get the opportunity.
Please.
Yes. So this is-
1,38,000 for the child. ma'am.
1 lakh?
38,000. That includes the baby clothing.
No, that
fooding,
what we do
accessories.
is let all that let the trial court decide about all other expenses, what you said. Now, yeah, we'll say let him for the boy, let the father pay 20,000 per month.
That will become a yardstick, my lord, for the family court also.
No, that we will clarify. No, nothing is before the court. Court is not looking at anything. At this stage, the court is saying it's always open to both the parties to agitate before the.
Let him pay the entire school fees, my lord. And the rest can be discussed
No.
there in the court.
Please understand, this is not the application in that. Now the court is only making an interim arrangement in this application. You can fight out, both of you can fight out your rights before the trial court.
20,000, my lord. What has also happened, which we have placed on record, he has claimed that he has 8 lakh rupees as his income. But he's showing expenses 3 lakh rupees per, his own affidavit says 3 lakh rupees expenses
Yes,
for his
Mr.
maintenance.
What is it?
What my,
Where is his
what the
liability?
respondent tells me, states his instructions
Found
that his mother herself had sent as to which school, what the breakup is. And he says it is 1.5 lakhs and not 3 lakhs. He's surprised.
Then we'll
They're
say,
coming
that-
up-
no. Whatever is the school fees,
Half of it.
50% of it has to be paid.
Half of it.
Let it be 1 lakh, let
Absolutely.
it be
He's
2
absolutely right.
lakhs, let it be 3
Half of it.
lakhs.
Please, we are fine.
So half of that he'll pay. Then this maintenance of 20,000,
He says he would start with 15 lakhs.
Huh?
He says he would start with 15.
15, yes, let him pay. And then, what do you say?
Visitation.
15 is too less, my lord, for a
That,
person.
you
I
understand?
will just show his
No,
affidavit.
no, please understand. First of all, that's not the scope of an inquiry before this court, but still the court is doing and keeping everything open to the parties to agitate before the trial court. Now that aspect is over. Will with this order passed by the, it will not come in.
I only request your lordship, my lord, direct the family court to dispose at the earliest, my lord, because this will become a norm that they will also go and argue. High court has stated so.
That I will know.
I will not do
You
that.
will,
Malad. I've
you will
been
know,
fair.
you will, when the court is dictating the order, you will listen to what the court is saying. Now then what about the visitation?
Lord, visitation rights, we have not stopped at any point of time.
Please.
Very
What
well.
is
I
it going
will
to be?
take my
Let's
submission.
forget about what has happened till now.
We'll bring the child to the family court visitation rights once a month on a Saturday. 11 o'clock to 2 o'clock, we'll bring the child in. So next, let there be so far he visited in our house, or she took the child along with her to when they went out. 3 or 4 times they've gone out. Otherwise,
He can come to
That
Bangalore.
is exactly
No,
what I've been
please
trying to
one
say.
minute. Can he come to Bangalore once in a week?
Once in a
Once in a week, can he come?
once a week, is it possible?
When he can come?
Once
when
a
he
week,
can come.
stays in Bombay. Once
He can
he
come.
says twice a month.
Yes.
Twice a month. My lords, all that I see, your lordship's intervention is that the order that's been passed by the trial court was for a reason. The order, in fact, told the mother could accompany or the representative, my lords. His family members, his brother flew down from Sharjah and he's come down from Dubai. He came down to Bombay just to meet the child. The expenses that have been spent, my lords, all that they could have done is they don't tell me until I arrive in Bangalore. When on 18th, when this man goes to her house, she messages.
Now, every 15 days
Please,
on a Saturday or Sunday.
please.
Saturday and Sunday.
Please, please, Saturday and Sunday.
Saturday and Sunday, or only Saturday. Ask your client.
Saturday and Sunday, 2 days. It can be with prior information. The problem is, my lords, he is in a profession which suddenly it would require him to travel. That being the reason, let them mutually, they talk over the phone. All that is, all of it is fine. I still
What
don't
is
understand.
that? They should be, do you think that if they can talk on phone, they're coming, there is no
That's
need
what
for
I
them
am
to come to the court?
My lords, I have messages, recordings. That's what the mother is doing.
There should be as a plan for her. You know,
He will
the
with
mother
prior
has her own work.
Sequence, my lords. Either
Whenever it is convenient to him, it won't happen. Now it is like this. It will be every 15 days on a Saturday.
Please.
That is twice in a month. On that day, if he can exercise a visitation, if it doesn't happen, on some other day, it should be compensated. It's 2 days in a month. Where
In the family court visitation.
Family
family
that's on-
court visitation.
Last
He's
2
gone to
years,
her
she has
place.
met the child. House they don't want, my lord.
But it's
Now, this is the problem that has happened. Last 2 years, that accommodation has happened and there are issues and therefore she says not. in the house.
can't he take the boy outside?
Yeah, he will drop the boy back.
So in the house, can't they take the boy outside?
Let there be, next 6 months, let it be in this, in
My
the
lords,
family court, my lord. Let it be in the family
No,
court. let me complete, Mr. Gautam. On Saturdays, 11 to 2. If it is any other day, afternoon, we'll bring the child to the mediation center. I mean, in the visitation hall is there in the fourth floor of the family court, my lord, we'll bring the child there.
No.
Then
in the-
after that, my lord, after 6 months, if there is a warning that happens and then it can take the child out, it can happen. Now also it happens, he will spend whatever, including all expenses, he will show. If you buy a coffee also, he'll say, I spent 10,000 rupees on this outing for the child. That's what he's been doing.
This is
So therefore, my lord.
very petty to make such allegation.
Sorry.
Very sorry.
Sorry, you have not gone through this, the petition or the.
No, I have.
liabilities.
I know. what
Kindly see, I don't think in any case I have filed this statement about assessment like this. Because we had to pay all the credit card bills, what she has spent on this child. And not for any other reason, but because of the nature of the person, that he suspects everything, show the bill. Even when, why the maintenance petition has not been disposed of, because give me the bill subject to the proof is what he is asking us. Now therefore.
Please
we
come.
put this for the-
My lord, may I just state, my lord, one submission. He's been meeting the child near the residence of the petitioner. He may be permitted to take the child out and drop the child back. Why family court, my lord? Why bring the child to court?
Yes, yes. Agreed with the orders passed and
My
I
lord,
number-
video calls also, since he stays there.
IA number
he-
14 in, what we do is he has, it is like, every 15 days he's having. So on other week, that is remaining 2 Sundays or Saturdays, let him have the video call at some point of time. In it. Agreed with orders passed in IA number 14 and let your client adhere to everything.
You can do that.
Please tell her.
Never stop. But only thing that he should call on fixed time, fixed.
That we will
that's all.
give the time.
My lord, she is not keeping well, because of which I made an application before the trial court seeking for interim custody, because she herself sends a message that she has chicken pox. The message says that she's supposed to be staying away from the kid. Now, since that day, I don't know how the child is. At least he may be, since he's here in Bangalore today, let him be permitted to meet the child today in the evening. Please, my lords, if that be a.
Agreed with the orders passed in I number 14 in MC number 816. Now, what you do is, whatever that school fees receipt is there, please send it to him. Please send,
It's already there, I will send it.
you
Okay,
please
once
send it
again,
to
I'll
him.
send it to the council.
Whatever is the school fees, half of it shall be, because she must have paid already.
Already
Half the
paid.
fees she must have paid. Whatever she has paid, let him give. So that would be the next term fees, half the term.
Year wise, it will change, please, my lord.
No, for this year, next year, anyway, your applications are pending. The agreed with the orders passed in I number 14 and MC number 816 of 2022, dated 14th August 2024. The mother is before this court. The mother had filed MC number 816, she had filed MC number 816 of 2022, seeking divorce. In that, she had filed an IA seeking, IA number, what is that?
3 and 4, my lord.
Seeking IA number 3 and 4, seeking
The maintenance for the
maintenance.
minor child and residence order for herself, my lord.
IA number 3 and 4, seeking maintenance and residence order for herself and the minor child.
Maintenance is only for the minor child, residence.
Maintenance for the minor child and residence for her. IA number 14 is filed with the father, seeking permission to take the minor child aged 4 years to Mumbai for 2 days to celebrate Raksha Bandhan on 19/8/2024. The family court had passed the impugned order whereby the mother is directed to hand over the interim custody of the child to the father for 2 days from 12 noon on 18/8/2024 to 12 noon on 28/2024 to celebrate the festival of Raksha Bandhan at Mumbai. As per the order, the respondent father shall pick the respondent father shall pick the child from the place of residence of the child at 12 noon on 18/8/2024 and shall drop the child at the same place at 12 noon on 28/2024. And also, the court is permitted the mother or the representative to travel with the child to attend to the needs of the child to her choice and directed the husband to provide suitable accommodation to the wife or her representative who will accompany the child to their choice or convenience to stay in Mumbai. Father was also directed to pay the entire travel expenses. And the father shall not take the child outside Mumbai. Also, the father shall accommodate the child to speak with the mother. And the court has directed the father to hand over the custody of the child to the mother at 12 noon on 28/2024 at the place from where he has picked up the child. And his interim custody is as long as the child is comfortable with him. In case if the child wants to go to the mother or a representative, he shall hand over the child. Agreed thereby, the mother is before this court, and counsel appearing for the mother submits that the boy is 3.5 years old. The what is the date of birth of the boy?
No, 14/9/2000.
14 September.
In September.
Born on 14/9/2023, and the the MC is filed. MC is filed when the boy is 13 months old.
Not 2020, 14/9/2020 is his birthday.
14/9/2020 is the date of birth, and the MC is filed
The case was filed on 7/2/2022.
7/2/2022. And looking at the age of the boy, and the fact that right from the childhood, right from the age of 1 year, as he was not with the father, the court ought not to have passed such an order. It is submitted that along with the MC, they have also filed applications seeking maintenance. Those petitions were not heard by the court. Applications were filed that were not heard by the court. But that is IA number 3 and 4 were not heard by the court even after 2 years. In this petition, even before passing an order whereby the granting visitation to the father, where the father will get acquainted and the boy will get acquainted with the father, the court had passed such an order. It is submitted that the mother was suffering with chicken pox, as such she could not comply with the order passed by the court. It is submitted that in any view, the trial court straight away, the family court ought not to have passed such an order. Next, it is submitted that right from the beginning till now, the father was never taking care of his responsibilities, but is only concerned with his rights. It is submitted that father has not contributed anything for the welfare of the child, and is only agitating or fighting for his rights. It's submitted that father has every obligation to take care of the child. Land council submits that the order of the trial court in granting the overnight custody of the father, that too at Bombay, was not a well-considered order. Next part. Land council appearing for the respondent, father submits that the mother had never permitted the father to meet the child. And several times, as he's a resident of Mumbai, he was traveling to Bangalore, and even when he came to Bangalore also, there was no prior intimation to the father of any of, and suddenly, once he comes to Bangalore, the mother will not facilitate the father to have the visitation. He has been continuously sending messages to her. In spite of that, there is no proper timely response from her. Land council submits that he has been on and off, he has been paying the money. When it comes to the school and other particulars are concerned, the father was never informed about which school the boy is studying and any of the details. It is submitted that, in fact, the father is ready to take care of the responsibility of the boy. He submits that, in fact, the mother is working and she's earning sufficient income. In fact, the father is a actor and is not having a consistent income, which varies basing on his work. It is submitted that as of now, his this year, his income tax returns are nil. Further, land council submits that the issue with regard to the maintenance is pending before the trial court. And basing on the evidence let in by the parties, the trial court will decide the same. It is submitted that the order of the trial court is he has to meet at the mediation center, which is not convenient for the boy and the father to have the bonding. Anything else?
Well, my visitation rights application is also pending before the trial court. In fact, I've also been.
It is submitted that the visitation, the application that is filed, now for the next 5 months, don't file any application.
I'm not. My lords, my visitation application is pending for next 5 months, my lords. My lords, this 14th is the son's birthday. He may be permitted to just meet his son. He
On
was
14th?
really hoping that he would.
No, what, if you agree for that, what you'll tell them is, let first the maintenance application be decided. Then now this interim arrangement is made for the father.
Please.
Now, even when the court wants it to be once in a week, now it is like, he's not, I mean, he has to travel every week, that's difficult for him.
My lords, my worry is.
No,
vacations.
that's why. No, even that, whatever that birthday, what he's saying, that day let him have.
Please.
And what I'm saying is for the next 5 months, don't let, if you want whatever, now already the visitation is granted now.
Please.
Whatever you want, any change or now overnight also is too young for a overnight.
My lords, in fact, overnight, I have been very vocal about it in the trial court that let the mother also accompany. I have never said that the mother should not accompany. Well, my family members are there. The problem is the son has not met his paternal side, my lords. How fair is this?
You have to be reasonable.
Been gracious enough to
No,
extend now, my lords.
you tell it that you're very reasonable, but that request is not reasonable. When the differences are there
once in a
between,
while, once in a
no,
while.
when the differences are there, why would she come?
Well, then why is she even talking to him, sending him messages? I placed those messages on record. Even I am really surprised. my
No,
lords, by
first
the
of all, let this arrangement go on for
Sir,
4
what
to 5
about
months.
vacations, my lords?
Huh?
What about vacations?
Vacation is a long time for vacation, December.
Dasara is also there, my lords.
Huh?
It is Dasara vacations are also, my lords. Something.
Then I'll not pass any order.
He's agreed to, my lords, not in such. He's agreed to pay maintenance.
Because every time here.
Times medical expenses are covered by his insurance policy, which everything is covered. It's just that he was never allowed to participate. My lords, something in Dasara. Something in Dasara vacation that people. Because my lords is putting me on condition, putting me on a condition that I should not file a.
No, you will come to,
application.
no, you will come to Bangalore in Dasara
I
vacation.
will have to probably.
Huh?
Once at least. Why not once? The mother's chosen representative.
No, let him come to Bangalore and exercise a visitation.
Overnight, my lords, in Bangalore.
No, then in that day, like,
Overnight, my lords.
no, overnight.
My lords, what instructions I have been getting is the messages are there on record, calls are recorded, which says that she wants to come, even she wants to go to Bombay. Well, that is the problem. That's what happened even in the trial court. I have, in fact, my learned friend appeared in the trial court. When I showed her the message, she was also shocked. Her client has sent a message stating that not this festival, any other festival I will send.
It can mean
Her
anything,
client
my
has
lord.
sent
It
that
says
message.
not this
Please,
year. It
please,
says
please.
not- He is very aggressive, very
No,
argumentative.
I'm so sorry.
Now, it is.
That's absolutely not
Your
right.
lordship, I kindly permit him to open his mouth, he will say what it is. And all are orchestrated talks he
My
makes.
lords,
He's
page
waiting
number.
for that. Anyway,
My lords, page number 3 of my memo. Please, my lords, I request, I plead.
What does it
Please.
say? It
May see
says
page
that
number
not
3.
now. Because how to ward him off? I can't keep on arguing with him. He'll make the calls, he'll go on calling, he'll go on making.
No.
messages.
She's also from Bombay.
No, my lord, she's in Bangalore.
No. Is she from Bombay?
No, my lord, Bangalore. It's for only for after marriage, she shifted with him and to Mumbai. She was studying fashion technology. There she went to Paris and then came back. They got married and she's staying there.
No, in October, in Dasara vacation for 2 days. Now let him
My lord.
provide.
No, my lord. Overnight visitations at this age, no, my lord. After some time, yes.
No,
After,
no, not overnight. Let him have it in Bangalore.
let him come to
Yes.
Bangalore, my lord.
My lords.
On
He
his
was-
birthday,
he was
come to
residing
Bangalore.
in Bombay before, prior to the wedding, my lords. Page number 3, my lords, please.
Sorry.
I am not really misleading this honorable court. Maybe another festival, not this time, is what the mother says, my lords. I don't know why this kind of submissions are being. She is fine with the child traveling. I am, in fact, since day one, I've been telling, send anybody child's choice or the mother's choice with him. Not a problem. My lords, if not in Bombay, at least in Bombay, when he comes on, one overnight at least. He wants to spend time with his son, my lords. My lords, I'm agreed to pay maintenance, which is his duty to pay. I'm not denying it,
How
my
the
lord.
child will stay overnight
How I
suddenly?
wish that he could get this, my lords.
No, how the child will stay overnight suddenly with, even it may be.
My lord, if not this month, after 3
Half
months.
an hour,
please,
he has
my
not
lords.
taken.
That's why I'm
the
saying
child.
after 5 months, you have the request.
At least
No, it
3
will
months,
not
my lord, 5
happen.
months.
It's not about right. You see, like after when the boy was 1 year or so, no, the mother is staying, he's staying with the mother. And as you also say that there was no acquaintance with, I mean,
The boy loves the father, my lords. That is my lords. In fact, I would in fact request your lordships to see the bonding. Let the boy be brought here. The boy, in fact, is upset whenever he gets to talk to his father. The boy has been saying, my lords, on the video call, he says.
After
3 months, my lords, not 3 months.
huh?
3 months at least. 5 months is too much, my lord.
Yes.
Please, 3 months.
What is that? Before that. Next para. Land council submits that in the ensuing Dasra vacation. And the boy's birthday is on September 14th.
14th.
On September 14th. On that also, there may be a direction that the father may have the visitation and overnight custody. Next part, having heard the counsels on either side, there is a material non-record. The admitted facts are right after 1 year age of the boy. The mother and father are living separately. Father lives in Bombay. Mother lives in Bangalore and she is working. It is also an admitted fact that towards the school expenditure of the boy, so far nothing has been contributed by the father. It is a case of the father that in between he has been paying an amount of rupees 10,000 to the mother, and according to the land council for the mother, he has paid an amount of rupees around
40,000-50,000 so far.
around 40 to 50,000. 50,000. The boy's age as of now is 3.5 years old. And when the boy is not staying with the father from the age of 1, giving overnight custody to the father at this age, at right now, may not be appropriate unless and until he develops acquaintance with the father. Then coming to the responsibility of the father, both the applications filed by the mother and the father for the maintenance of the boy, residence orders, and also the visitation are pending before the trial court. This is an MC of 2022. Considering the requirement of the father to meet the father and also the mother and the maintenance of the boy. This court is passing the following order. No, before that, the father, when he is very much interested to meet the boy, it is his responsibility to take care of the child. When applications for interim maintenance are filed, the trial court ought to have decided those matters at an earliest point of time, immediately after service of notice on the other side. And when an application is filed, the court has to decide the same within a reasonable time, in spite of repeated orders on the judicial side and also on the administrative side. It is very unfortunate that in this case, though the applications were filed in the year 2022, so far, no orders are passed by the family court. The more these petitions are pending, the disputes between the parties and also the frustration of the parties is also resulting in in further litigation, considering all this and balancing the interests of both the parties, this court is passing the following order. Number one, the father on first and it is like first Saturday,
First and third Saturdays.
Third Saturday.
person on first and third Saturday can exercise the visitation. On that day, he can pick up the boy at 11 o'clock. 11 o'clock.
Initially, we'll bring the child to the family court, my lord. After that, he can take the child outside,
My
once
lord.
his bondage is built.
How
And
much
that will
would
let the mother be present well.
Madam, how much would I have to concede? in?
No, right from the beginning, let the mother be present and let them go up. Father
let them
can
be in
take
the
the
family
child.
court, my lord.
Father can take the child, pick up the child at 11 o'clock. If the mother wants to accompany the father, she can also accompany and can drop back the child at what time? 4 o'clock?
2 PM, my lord. But initially, my lord, may I make this request, my lord? Initially, let it be in the family court, and after 4-5 months, he can take the child.
My lords, I have objections to that.
By, shall drop the child at home
2
by,
PM.
by 4 o'clock.
Lunch time will be there, my lord.
Lunch she can have by outside also, by 4 o'clock. Next, on second and fourth Saturday, the father can speak to the child through video call between 10 o'clock, 11 o'clock, between 11 and 11:30, subject to the
10 AM, my lord,
My
10 to
lords.
10:30.
between
I have
10
met-
to.
Video calls at least, my lords, alternate days, at least video calls, my lords. Eyes.
No, that's a.
Bonding, my lords, they claim there is no bonding, I claim there is
So
bonding.
let's go,
That-
let
that
it
means
go
it,
like
my
that.
lords, please.
On Saturday, between 10 and 10:30, the father can have the video call. The mother shall cooperate with the said arrangement and facilitate the father to exercise the visitation smoothly. Next, the application, the mother shall pass on shall send the school fee receipt, school fees, the details to the father, and the father shall pay half of the school fees of the child within 2 weeks from the date of receipt of the copy of the order. Next, the father shall continue to pay an amount of rupees 15,000 by 5th of every succeeding month for the maintenance of the boy. Next, the application of the mother, that is IA number 4 for the maintenance of the boy, 5 for residence.
2, my lord, 2, 3.
2 for the maintenance of the mother is pending before the trial court. This arrangement is made by the court, considering the fact that right from 2022, the applications are not heard by the court. The court shall hear the applications on the merits of it without uninfluenced by any of the observations made by this court, shall pass orders. Next, it is stated that the birthday of the boy is on 14th of September. 14th of September, on that day, morning or evening?
Evening.
On that day evening, the father can pick up the child at 4 o'clock and drop him back at 7 o'clock. Here also, if the mother is
Mother will
interested,
go along with him.
if the mother is interested, she can accompany or his father will take.
Say that he can't come. Mother will.
No,
accompany
mother
the
will
child.
accompany if she is interested. Next, then even during the Dasara vacation,
My lords, one aspect is missed out, the days that he would probably, due to prior commitments. if he's not able to-
whenever the father, due to his work, if he is not able to exercise the visitation, an alternative day convenient to the mother in the said week shall be given.
Not on the weekdays when a child has to go to school.
Not the week, no, it is
By a mutual,
It's
let
an
them
alternate.
convenient.
And timing also, my lord, not only the time, now 11 AM to 4 PM. Then it will be
The other
whole
days
day,
it would be school will
Then
be
it will
there.
be school, she
Then
will be having
Any
work.
other weekend, my lord, any other next, the ensuing weekend.
If that is not that week, next week, and that has to be,
Prior explanation.
it shall be compensated in some other Saturday. The father shall inform the mother about, if at all he is not able to exercise the visitation, in advance, it shall be informed to the mother. According to you, how advance means how advance it is?
Yes, tell me.
It should be, it should 2 days prior to that. 2 days prior to the
He'll
visitation.
ensure that he.
It shall be
has a plan straight.
informed to the mother next.
1 week at least, my lord, you can't say, no, but I'm coming tomorrow, not coming tomorrow.
My lord, I should in fact start making
He,
some.
he will get a schedule for the work much in advance. It's not that tomorrow's shooting schedule, he will get it
Yes,
intimated now.
what else, before that, what did you write?
The school gets over at 11:30 apparently, my lord.
No,
Oh.
Please ask your
1:30.
I am making.
And during the, you said during the Dasara vacation,
For him to get.
any of the, any 2 days, the father, with prior intimation to the mother, can come to Bangalore and exercise the visitation as, between the 10 to 4 with the presence of the, in the presence of the mother. Next. I think everything is covered. Huh? Dasara, that's what I said. Yes, accordingly disposed of.
Grateful, ma'am.
it would be good, my lord, initially if it is in the mediation center. then
Next,
also
the
fight
father,
will not be over.
1 minute, the father
There are no fights.
can renew his application for seeking any modification in the visitation after 4 months.
My lord, sir, just for 3 months, please, my lord.
3 months.
Till number
Grateful, ma'am.
20.
Amel Hage, but they'll be
10
making that.
KBS.
6 months, let this arrangement
My
be for
lord,
6 months. my lord.
Can't have the cake and eat it. Everything, my lord. No, no, I'm so sorry.
My lord, again,
My lord, 3 months.
Lord, the applications
madam.
will not move. In 3
20.
months, the maintenance petition will not be disposed of. Let there be a time frame, my lord. Our application for summoning, he has a second account. He has a joint account with his
I said
mother.
the IA has to be disposed of as expeditiously as
Yes,
Time frame may be given.
3 months for the IA for maintenance.
please. Oblige, ma'am.
Till number 20, KBS money and.
For the appellant.
Appearing for respondent. my lord.
Or
My lord,
Serial number?
20.
Plaintiff's appeal.
due to some personal inconvenience, senior had to leave, my lord. Had to be posted for tomorrow.
Tomorrow's fine.
Post this matter tomorrow. With the request of non-constitutional the respondent. Huh? Tomorrow is. Yes.
Till number 21,
Here on behalf of the advocate for the petitioner.
free contest.
For the appellant. Plaintiff's appeal on an application under order 39 rule 1 and 2. Initially, the order had been granted in my favor.
Hmm.
Subsequently, at the final hearing, it has been rejected.
What is?
Suit is for partition between plaintiff and her brother, siblings. Plaintiff and defendant are siblings. Plaintiff is a sister, defendant is a brother. Plaintiff has filed for a suit for partition in respect of grandfather's properties which had come from the grandfather. Apparently, the defendant admits the plaintiff's share, says that the plaintiff has a share. But his only contention is that some of the properties are self-acquired properties. That is a matter of trial. On that ground alone, the court has rejected my application for stay. That's the only ground. That we'll have to
You
examine.
sought for not to alienate.
I only sought for not to alienate. Initially, it has been granted. Since 2022, the order has been there.
Prima facie, if it looks to the court that they are joint, they are not joint family properties, court would not grant.
My law, I'm glad my law has hit the point. Prima facie, there has to be some finding. It is
Let's
only
see
a
that.
mere plea.
Let's see.
Let's see the order. I would bow down to that. If prima facie, there is enough material to show that these are not joint family properties, then that's a different matter. At ink page 17, the order begins.
17.
16, but
Yes.
the reasoning is to be seen at page 26, para 12. May I just point out before we come there, at page 25, the trial court takes note of the fact that the defendant concedes that I have a share in the properties. All that the defendant says is in respect of which properties has to be determined. He concedes that I have a share. That the plaintiff at page number 25, 3 or 4 lines from the top. The plaintiff, defendant and.
What is the age of the plaintiff and the defendant?
Plaintiff is 57 and 60 at the time of filing of the suit in 2022. Plaintiff, defendant and the mother got their share of the property at the rate of 1/3 of 1/5 share of Dadda Muddappa. He says that yes, there is a share in the property of the father. There is a deed of partition which they have executed without involving me. At para 12, the reasoning of the court is to be seen. All that the court says is that partition deed without me is admitted, share in the property is admitted, but defendant's contention is that there are some of the properties are not joint family properties. That is the only reason why I will not confirm the injunction. That cannot be a reason. Indeed, this is a matter of trial. In the meantime, the properties cannot be frittered away. And it's a different matter if the defendant had produced material. There is no material on record. And my lord will see that at ink page 44, at ink page 45.
Can you please read from para 11?
Para 11, certainly. On perusal of pleadings, IA, affidavit, objection and documents, it is found that there is no dispute about the relationship of plaintiff and defendant. The plaintiff is a younger sister of defendant. The plaintiff and defendants are children of Dadda Muddappa. As per plaintiff, the suit schedule property, as per plaintiff, the suit schedule properties are joint and ancestral properties of the plaintiff and defendant. By virtue of a registered partition deed dated 5/8/2006, the defendant, 2006, my lord, this is after the Hindu Law Amendment, section 6, where I have a right by birth. By virtue of registered partition deed of 2006, the defendant and his uncle's children have entered into partition wherein some of the suit schedule properties were allotted to the share of defendant. According to plaintiff, she and defendant are in joint possession of the suit schedule properties, but the defendant has refused to effect partition when the plaintiff has requested the defendant for partition over the suit schedule properties. The defendant has denied the claim of partition by the plaintiff herein, contending that the suit schedule properties are not the joint family properties of plaintiff and defendants. Late Chikka Muddappa has released his right over the portion of suit schedule properties. Hence, the property cannot be treated as joint family property. Pursuant to the partition deed, the defendant has got khata transferred in his name and he is in possession and enjoyment of the same. Hence, the defendant contended that plaintiff has no right or share in the suit schedule properties. According to defendant, the property was not enjoyed as joint family property, and as members of joint family after the death of Dadda Muddappa, the plaintiff, defendant and their mother got their share of property at the rate of 1/3 of 1/5 share of Dadda Muddappa. The deed of partition dated 6/8/2006 recognizes the said enjoyment and confirmed absolute right in respect of 20 guntas in survey number 22 in favor of defendant. Further contended that Chikka Muddappa, who was not having children, has relinquished his right over the joint family property in favor of the defendant here. Hence, the plaintiff has no share or right over the property relinquished by Chikka Muddappa. That no document to support the relinquishment, my lord. It is further contended by the defendant that he has purchased 18 guntas of land in survey number 20. Hence, he is the absolute owner of the said property and the plaintiff is not entitled to claim any right in respect of the suit schedule property. According to defendant, the marriage of the plaintiff got performed by the defendant and mother of the plaintiff and defendant by spending huge amount in the year 1988. Plaintiff was given gold and silver articles. The defendant has repaid the loan with interest to the lender. It is further contended that the plaintiff is not entitled for any share of the property allotted to the share of defendant. But plaintiff.
No, which property is purchased by the defendant, self-acquired property according to him, as per the schedule at page 33.
I come.
34.
34. Well, the written statement, I'll identify the property which he says this is.
33 is the list. 33 prayer, thereafter the schedule of the properties.
My lord, will give me a minute. There's 18 guntas of land in survey number 20. My lord, that will be 18 guntas of land.
Better let there be a notice.
Item
Let
number.
there be, please, let the notice be taken. We'll decide.
My lord, may I just point out one page, page 45.
No, in all these cases, instead of passing so many orders,
May I only request this, that there has already been an order of injunction operating in my favor at page 45 since 2022. It is only now in June 2024 that this order has come to be vacated. Let that be maintained until notice.
So when is that, when is this order granted?
This order was granted, my lord, we'll see on 17/12/2022 under the signature at page 47.
17/12/22. It was till what time?
Till the date of the impugned order.
What is impugned order? When is the impugned order?
February 24. And he has not filed any
The
application.
appellant, who is the plaintiff in the suit, is before this court agreed with the order passed by the trial court, whereby the injunction that is granted in favor of the appellant is vacated. It is submitted that right from 17/12/2022 till February 2024, there is an injunction in favor of the plaintiff restraining the respondent defendant from alienating the property. Considering the same, the respondent is there shall be an injunction directing the respondent defendant from alienating the properties till the next date of hearing.
Okay.
Petition is permitted to take out notice and take out the hand summons to the counsel appearing for the respondent before the trial court and file a memo to that effect by 20th September. List this matter on 24th September. If the memo is not filed by 20th September, the stay granted by this court stands vacated automatically.
Grateful.
Yes.
Till number 34.
Lordship said that at 2:30 you are going to.
Tomorrow, this matter on the top of the list will have.
Top of it.
The post this matter on the top of the list. Yes,
Number 36.
page number?
36.
For the petitioner in this.
Yes.
With regard to that CCTV footage, my lord.
Yes. Why they are, why?
I'm not, I'm also resident over there. Let them, I have no objection for them to get it. I had.
Because you're a resident there, you have to get it.
I'll apply.
The respondent shall file the CCTV footage and also the association of, what is that?
Misty Waters, Prestige Misty Waters.
Prestige Mystery Waters are directed to give the CCTV footage to the petitioner father as requested. Post this matter and the respondent shall also file the CCTV footage as stated by them by post this matter on 25th.
One more submission. That whenever the mother can't give the visitation rights, there is an order by this honorable court to give alternate date. When father is not able to visit on the particular date, they are not providing an alternate visiting. That there should be an order saying that even if the father cannot exercise his visitation rights.
Whenever the father is not able to exercise the visitation as per the orders of this court, at the convenience of the mother, an alternate day shall be provided.
One more submission. But there was an order by this.
It always should be from him. Why you are saying
No,
so?
because from the school, this honorable court has directed the mother to include his phone number also in the school record.
That is in some other case.
One second.
That's in some other case, an order is passed.
Because now there was a grandparents' day which was fixed by the court on by the school on 6th of this month. It was preponed to 3rd of this month. It was not informed by the wife to the.
Why his number is not added in the?
Email, I have sent an email marking a copy to him. He's getting all the emails from the school.
That's what it was preponed. It was sent from the school.
No, if you are getting direct emails.
No, my lord, I'm not getting it.
No, that's what they are saying.
That's what I'm telling.
By the next date of hearing, the learned counsel, the respondent shall submit before the court whether the name of the petitioner is entered in
phone
the.
number is
I
phone
have
number.
the email with me.
Name of the petitioner and the phone number is entered in the school, what is that, in the school group to get the updates on the happenings in the school.
Yes.
Yes, next. Yes.
Till number
I'm sorry, I have one request. Since your lordship's order for maintenance does not specify any date, when it's coming haphazardly, a date may be fixed for him to deposit the maintenance.
Date is not there in that.
Date is not, by 5th of every month, let him deposit.
Depositing.
It will be overlapping in that. If you just move are being spoken to, there only will tell in that order. Because there will be a lot of confusion in which phase it's happening.
Yes.
Already he has, one is included, which is not part of this. Yes.
Till number 37. SF
Yes, madam.
Tanvi.
Appear for the appellant in this.
Therefore, the respondent, my lords, may be taken up tomorrow, my lord, senior on his legs, my lords.
Tomorrow not possible. Let it be on
My
12th.
My lords, one
12th.
DSGI, please, my lords, DSGI name may be shown in the cause list, my lords.
Give it, whatever it is. Yes.
What date is?
Yes, at the request of land council, the respondent poses matter on on 12th. Yes, next.
Still number 38.
Instead of 12th, 13th.
13th, yes.
I pay for respondent number 20's counsel. This is a case where I appear for respondent number 20's.
Tomorrow, how many matters are there?
Tomorrow will be some difficulty.
Then 12th, poses matter on 12th. At the
Please,
request of
12th.
land
So
council, the
great.
respondent.
Small submission. This matter may kindly be, my 37th matter may kindly be had on top of the list because I have to come from Hyderabad.
Yes, 37 on the top of the list on that day.
Hello.
Yes, next.
38 on 12th, the court indicated. So great.
So which top of the list?
Can I
is
make
that?
one submission? My learned friend and I are appearing for respondents. I don't know why we are to be anxious or appellate should be anxious.
No, we'll have it that day.
12th,
It
12th.
will,
12th,
yes,
12th.
next.
Still
Call.
number 42. Patina JD.
I'm appealing to the petitioner, my lords. This petition is dismissed for non-prosecution, my lords. Permitted to show
Great.
some or earlier orders of this honorable court.
Poses matter also on 12th. Yes,
My
next.
lords, there is a
Still number
urgency.
45.
Tomorrow, my lords. Kindly tomorrow, my
No
lords.
time tomorrow. So many matters are there.
45.
Yes,
Lord, the trial court enhanced the maintenance.
which case?
45.
45.
Uh,
From 1,000 to 5,000 without considering.
45 tomorrow. Yes, next.
Please.
46.
Your Lordship,
Balram.
the maintenance issue.
48. There's a delay. We'll order note. You're there.
The notice is already.
And for respondent.
Delay can be condoned.
1 week.
Delay can be condoned.
Yes, your Lordship.
IA number 3 of 24 is filed to condone the delay of 163 days.
My lord, I have to file the objections, my lord, for the delay application. I am on record.
For filing objections.
Please, my lord.
Poses matter on
Thank you.
12th. Yes, next.
Grateful.
48.
48.
I am
Right.
respondent.
Not in other matter.
Ananya Rai.
Weeks space time.
You file the vacate. You have no urgency. Yes. At the request of land council for the respondent, poses matter on October 21st. Interim order earlier granted is extended till then.
Still number 50. 49.
49. Yes.
Ajesh Kumar.
Any date, my lord, next week or this?
49,
29.
12th, 49.
My lord, we may be permitted to place on record some additional documents.
Petition is permitted to place place additional documents. Yes. 50.
Number 50. Manjula Kamadulli. Kumar MN.
Yes. Poses matter, no representation, poses matter on October 12th, 21st. Yes.
51. 21.
Yes.
Serial number 50.
Lord, one submission.
Yes.
3, serial number 15, my lord, compared with all the office objections.
You come 50.
This 3, serial number 15.
What has happened to that?
Has been adjourned to Tuesday, my lord.
Uh.
The participant can't be trying to.
You have already complied. In serial number, Anita, take that. In serial number 50, office objections are complied with. Land council submits as the needful is done. Post after service of notice. Notice for that is coming.
No, my lord, it's not been issued yet. This 3, serial number 15.
Anyway, it will come on Tuesday.
Not the
Just-
complaint, just filing the-
No, but everything has to be removed now. That's, please understand, there will be a lot of confusion. Please file in the registry. Yes.
That first list, serial number 50, my lord. 48 to 50 connected. October 24. Please, my lord.
Which one?
Appellate on that.
Please understand, you people are getting confused and confusing the court. How many times?
Serial number 50.
Yes.
First list, my lord.
2110. October 21st.
She says 47 and 48 are connected.
47 and
How is it connected? Neither the aggregates are common. For whom you appear? What is the advocate's name?
Commander.
Manjula Kamadulli. Sorry.
48.
And for appellate done that.
Where is 48?
48 also.
48 responded. In 50.
Appellate.
In which list? Which list she is referring to? Which is, where is Manjunatha? Both of them are connected. Where is it connected?
In there, in there ahead of the time.
48 ಅಲ್ಲಿ
I'm not
respondent
able to
name.
understand this. Where is this Manjula Devi's name in this case? See this, the 47 and 48 are.
Same date.
Can you just check what is 46 date?
ಎರಡು 21st ಗೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅವತ್ತು ಹೇಳಿ
ಅಷ್ಟೇ. Maybe taken up together.